yeah. Yeah, yeah. Like, swords up, throw it up, throw it up, throw it up, throw it up. Swords up, throw it 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 up. Like, throw them swords up, throw them swords up. Where you at, where you at? Throw them up, throw them up. Avengers, where you at, where you at? Throw them up, then slice and dice, then slice and dice, then slice, dice, 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 then slice and dice, then slice and dice, then slice, dice, 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 dice. Danny in the house, in the house, in the house. Avengers in the house, in the house, in the house, in the house. Swords up, turn up, turn up. Let's get messy, let's get nosy, let's go, let's go. Give him the tea, give him the news, give him the biz, give him the mess, the mess, the mess, the mess, the mess, the mess. Swords up, throw it up, throw it up, throw it up, throw it up. Swords up, throw it 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 up. Hey, throw them swords up, throw them swords up. Where you at, where you at? Throw them up, throw them up. Avengers, where you at, where you at? Throw them up, then slice and dice, then slice and dice, then slice, dice, 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 then slice and dice, then slice and dice, then slice, dice, 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 dice. Who gon' check me? I'm playing chess, you playing checkers, checkmate, checkmate. Next caller, swords up, swords up, swords up, swords up, 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 up. I don't like you, can't stand you. If it's stuck, then it's stuck. Get stuck, stuck, stuck. Swords up, swords up, swords up, swords up, 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 up. You're mad, they mad. You're pressed, they pressed. Got you bothered, they bothered. Got you triggered, they triggered. Swords up, throw it up, throw it up, throw it up, throw it up. Swords up, swords up, swords up. Throw it up, throw it up, throw it up, throw it up. Hey, throw them swords up, throw them swords up. Where you at, where you at? Throw them up, throw them up. Avengers, where you at, where you at? Throw them up, then slice and dice, then slice and dice, then slice, dice, 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 then slice and dice, then slice and dice, then slice, dice, 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 dice. Let's go, start the show, symbol, we in chill, let's go, Avengers, assemble, lights, camera, action, we ready, stay ready, stay ready. Swords up, throw it up, throw it up, throw it up, throw it up. Swords up, throw it 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 up. Hey, throw them swords up, where you at, where you at? Throw them up, Avengers, where you at, where you at? Throw them up, then slice.
everybody. How y'all doing? I apologize for the wait. Yes, we are on the backup channel, Truth Teller Danny. Yes. And let's go ahead and get into some updates. And yeah, so Shanquella, and I will be updating the petition as well. Give me time. And we have to go over the documents since my last update. And right now, I will say it's at the stage where people are really trying to get it dismissed on technicalities and procedural issues and not really going over the merits of the case, which is, the truth and the facts. And that's where we will get into a lot of it. Once it gets to that stage, I feel that more information will come out because at that stage and at that point, everyone that has been served, all of the Cabo, they will all try to defend themselves because they have, most have lured up and they will try to defend themselves. And when they try to defend themselves, they might have to throw others under the bus and tell on others, right? You have to tell your part in it to defend yourself. And once you tell your part, you might have to tell what others were doing as well, because obviously you don't want to be held liable for someone else's actions. So we're going to go over the documents. Now, some of these documents are going to have more information than others, okay? So at first, when they started this lawsuit, they were suing the FBI because the FBI had not released information from FOIA requests and things like that. And they were also suing other government entities as well. However, since that time period, the government, Department of State were being sued. They pretty much were able to get out of the lawsuit, should I say. And since those bodies were no longer in this lawsuit anymore, the government entities, there was no need for it to be in district court or federal court. So now it has been remanded and sent back to the Mecklenburg Superior Court to be heard. And okay. So that's why it kind of took long too, because at first there was a fight with the FBI. And then subsequent to that, the FBI did release information, but it was lackluster, wasn't a lot of information, a lot of redacted information. I already sent that out via the petition and discussed that previously. And so the civil case is now back with Mecklenburg County Superior Court. And that's again because of the federal defendants, the FBI and Department of State. They were no longer keeping those government entities in this in the federal court case. So now that it's back in California State Court, the defendants are trying to slow it down and pretty much dismiss parts of it or argue North Carolina is not the right place to handle it. We all know this happened in Cabo, right? This is happening in Cabo. Mexico people are saying that this should be handled there and not in the United States. And a lot of times that is the case. Wherever something occurred, that is usually the jurisdiction. However, that's not always the case. Sometimes it's also the place where the victim lives, or can also be where the harm occurred is where it happened in Mexico. That's the proper place. It also can be a lot of times where sometimes where the defendant lives. Let me say the defendant lives. And a lot of the defendants are out of North Carolina. So ultimately, of course, Shanquella's sister and mother, the whole family really wants justice for Shanquella. That has not stopped. The person that is the named on the lawsuit is Salamandra, which is Shanquella's mother. She's the one actually on the actual case. The lawsuit is filed under her name, okay? And essentially, when it's in this stage, they are really just trying to get it dismissed based on jurisdiction, stating that this is not the proper location or the proper venue or the proper courthouse to hold the actual court trial. Okay. Or they're trying to get it dismissed by saying they were not properly served, and or this is not the right place to hear it. It should be heard in Mexico or a different state. So essentially, that's where we're at now. Okay. So let's go ahead and look at this first document. I'm gonna make sure I go through it's a lot of documents since the time I updated, right? And let's go here. And again, this is just going over what I just said. Plaintiff originally filed this action in Mecklenburg County Superior Court, the Federal Bureau of Investigations, and the United States Department of State. The State Department removed this action to this court, invoking this court's subject matter jurisdiction. Their author, plaintiff, filed an amended complaint which stated that jurisdiction is proper pursuant to, and they gave that. It says the amended complaint asserted various state law causes of action against the individual defendants, negligence against the FBI and State Department through the Federal Tort Claims Act, and failure to release records pursuant to the Freedom of Information Act, FOIA, which I had also requested information I never heard back, right? Now, at the time, I will say this, at the time when I was heavily reporting on Shanquella, I was in contact with the FBI publicist, media representative. And I will say that she would respond to me, and she would, even when she sent out stuff to the media, she would also include me in it. And I think that's because I had told her initially that I was in charge of the petition. And since I was in charge of the petition, she probably saw how many people had signed it. So she included me in her media releases, which I thought that was, at first when I told her that I was just in charge of petition, I wasn't actually with the media, like in that way. I thought that she would, start ignoring my emails, but she actually kept on until, that last time when, they said that they were not going to pursue the case, okay, with the FBI, where they were not going to press charges or whatever, okay. And it says right here, against the FBI, additionally, plaintiff alleged that she and the individual defendants are residents of North Carolina. And it says the court dismissed plaintiff's claims against the FBI and the State Department on June 13, 2025. First, the court determined that it lacked subject matter jurisdiction over plaintiff's tort claims because such claims were barred by the Federal Tort Claims Act. Second, the court held that it lacked derivative subject matter jurisdiction over plaintiff's FOIA claims because those claims were originally filed in state court, which did not have jurisdiction over them. Accordingly, plaintiff's only remaining claims are state law claims against the individual defendants. So once they got rid of all the federal claims, there was no need to hold it in federal court anymore, and they decided to not take supplemental jurisdiction, which is sometimes they can take supplemental jurisdiction and still hold the case in district court, but it looks like they decided to go ahead and remand it or send this back to state court once there were no more federal claims left, okay? And it says on November 5th, 2025, the court ordered the parties to address whether this court has federal question or diversity jurisdiction over plaintiff's remaining claims. And if not, why this court should or should not exercise supplementary jurisdiction over plaintiff's remaining claims. The parties agreed that this court did not have either federal question or diversity jurisdiction over plaintiff's claims, but they disagree as to whether this court should exercise supplemental jurisdiction over this matter. Defendants argued for jurisdiction and plaintiff argued against jurisdiction. Now, for diversity jurisdiction, you need all the plaintiffs and all the defendants to be in different states. It has to be diverse. And in this case, the plaintiffs and defendants, they're not all in separate or different states. So with that being said, it was not diverse, so it was no diversity. Also, there was no federal questions like federal statutes or other things the court was going to be reviewing. So since there was no more federal claims, there was no point in having it in federal court. And then now it's back to the state court. So to be honest, that took a long time to get to that point. Okay, so now the government bodies are pretty much out of this, and now it's just, her mother, fighting for Shanquella. Like when I say mother, I mean family. I'm saying that the mother is on the case caption. It's gonna say Salamandra, okay? Versus the defendants, okay? And it says courts have an independent duty to ensure jurisdiction is proper, and if there is a question of jurisdiction, courts must raise lack of subject matter jurisdiction on their own motion. Okay, so once they didn't have that, so that's why they had to go ahead and send this back to lower court. And it says every federal appellate court has a special obligation to satisfy itself not only of its own jurisdiction, but also that of the lower courts and cause under review, even though the parties are prepared to concede it. And it says remand is the appropriate remedy when the court determines that it lacks subject matter jurisdiction over a removed case. Okay, if the court has original jurisdiction over at least one plaintiff's claims, the court may exercise supplementary jurisdiction over plaintiff's other claims that are so related to claims and the action within such original jurisdiction that they form part of the same case or controversy under Article 3 of the United States Constitution. Generally speaking, the exercise of supplementary jurisdiction is discretionary indeed, states the court. However, a court has no discretion to assert jurisdiction over supplemental state law claims when it does not have subject matter jurisdiction over the claims that supposedly arose under the court's original jurisdiction. And it says, in other words, supplementary jurisdiction may only be invoked when the district court has a hook of original jurisdiction on which to hang it. Without such a hook, the supplemental claims must be dismissed. This is so because I'm not going to read all of this because people can get like, okay, let me get into the other topics. But pretty much I summed it up that because they didn't have the subject matter jurisdiction over this case, like federal questions to take this to court, or pursue this for trial. And because there was no diversity, the plaintiffs and some of the defendants live in the same state, so it's not diverse. Then they had no choice but to remove this from federal court and take it back to state court. So that's what was happening for a great part. To be honest, it looks like almost like a year of this case was spent on that whole jurisdiction, which that can't happen. So that's why it says, accordingly, the court is left with no choice but to remand plaintiffs to Mecklenburg County Superior Court. And that was ordered on January 28th, 2026. And I'm telling you this, the fact that this was ordered January 2026, this lawsuit had already started years before that. So this whole time, all the way up into January, it was a fight, a literal fight about whether the federal court should have this case or the state court should have the case. And now we're at state court, and now we're fine. The ball is going to be rolling faster now that it's in state court. And don't forget, at first, it did start off in state court. And then when the federal government, FBI, and the State Department said, hey, we're supposed to be heard in federal court because, so then it had moved to federal court. But then once it got to federal court, the FBI, and once the FBI and State Department was pretty much saying, we shouldn't even be sued about any of this stuff. And they pretty much got out of being sued based on FOIA and other things. So then once all the claims were taken back, were dismissed against the FBI and the State Department, there were no more federal claims. So then it had to go back to the state. So then that was that back and forth. Okay. Now let's go here to the next document. So that takes us to January 2026, right? Yeah. This right here is just showing how this whole case started. I think in 2024. It could have been 2024. I thought it was earlier than that though. 2023, 2024. But yeah, so that brought us up to January 28th right here. And let's see what this one is right here, the third document. So Nazir Wiggins, one of the Cabo, Cabo 6 right here. Notice is hereby given that the undersigned attorney will appear on behalf of defendant Nazir Tyree Wiggins as counsel in the above captioned civil action. You are hereby requested to forward copies of all pleadings and documents to the undersigned this 17th day of February 2026. So this is going down to February, and Nazir Wiggins obviously now has a lawyer, right? And as you recall, during the whole Shanquella reporting, Nazir Wiggins also is someone that I had spoke to, who sent me, flight tickets, information, and a video of him arriving to Cabo. And we had, a lot of discussions. And for those that are new, that's nothing new. If I'm reporting on something, I like to talk to people involved, because obviously if you talk to people that are involved, you can get information. Okay. Ultimately, when I did talk to him, I did let him know that my priority was to Shanquella, that I was behind the petition. So there is no misunderstanding that what side I'm on. Okay. It's only for me to get information. And that was including me talking to the concierge and different other people that were involved, even calling the paramedic, different people. Okay. If you are here, So let's go to the next document. Now, is it smart for people to have a lawyer? Most people are going to have a lawyer, okay, for this type of case, especially when it's criminal. Now, I will say it's easier to get a criminal lawyer, defense lawyer, than it is to get a civil lawyer. Now, let's go to the next document. And this one says, now comes defendant Imani Green. Now, as you recall, when she first changed her names, I reported on that she changed her name. And then I also contacted the family to let them know. And from there, they let others know. And then it spread, okay, that Dani'S Manhan Jackson had changed her name to Imani Green. So now that's her name, okay, Imani Green. For those that are unaware. And it says, now comes, so I will say, when I say Imani Green, understand I'm talking about Dani'S Jackson. And sometimes I will reiterate that and repeat that, so everyone will know that Dani'S Manhan Jackson is the one that's now named Imani Green. Now, here's the thing: when you change your name, people think they get to change their name, but a lot of times when you change your name, you have to change your name in the same county that you live in or reside in. And when you do, unless you can get that information sealed, people can just look up that county records and your name, it will pop up. The name change document will pop up, and people will say, okay, well, Dani'S Jackson is now Imani Green. So there's no point. Yeah, she tried to change her name, I guess. If you Google Dani'S Jackson, it's everywhere. And when she goes to try to get a job and things like that, her name's all over the internet. She probably wanted to change her name. And I said, everyone needs to blast this name, Imani Green, everywhere, when I was reporting on it before. But yeah, so if you change your name and it's in the same state, in the same county, people can just easily see that you change your name. So it's pointless unless you plan on moving elsewhere, but everyone in that county that knows where you're at, they're obviously gonna just be able to see, you change your name. So anyways, now comes defendant Imani Green, formerly known as designated Manhan Jackson, buying through undersigned counsel. Undersigned counsel moves this court to dismiss plaintiff's amended complaint. And pursuant to rules 12B2, 12B4, 12B5, and 12B6 of the Federal Rules of Civil Procedure and North Carolina Rules of Civil Procedure, the lack of personal jurisdiction, insufficient process, insufficient service of process, and failure to state a claim. So 12B6 is failure to state a claim, pretty much saying the lawsuit is not really stating a claim on which relief can be granted. It's not a fully pled claim. Also saying that it was she was not properly served. And also she feels like there is a lack of personal jurisdiction. Now with Dani'S Jackson, you know, her address was listed as a North Carolina address, but then there was another address which was listed as a something about Connecticut. So I will have to get to her later filing to make sure. But for some reason, she's arguing personal jurisdiction. And so we have to make sure of that as well. And you have to target a certain state. So now let's be honest here. Usually when people file a motion to dismiss, they are going to file every motion to dismiss they can. They're going to do the 12B2, they're going to do the 12B4, the 12B5, 12B6, sometimes even the 12B1 subject matter. They're going to try to dismiss it on technicality and procedural things first, okay? If you can get it dismissed on the procedural, you never have to go to trial. You never have to argue any of the facts of the case or the merits of the case. You can just try to get it dismissed and say you weren't served, and then it could be over. So she's trying to get it dismissed on technicality and procedural things, so she doesn't even have to go to trial, okay? So I hope I got that across. So now let's go see the next document. The next document is, now comes Elliot A. Fuss of the law firm of Blanco, Tackleberry, and Matamoras, PA, and hereby gives notice of his appearance in this behalf of defendant Imani Green. The undersigned respectfully requests that copies of all notices and filings in this action be sent to the mailing address and our email address listed below. So this is, she has representation, okay? And this is document number 8. So let's go to the next document. Okay. It says notice of hearing. And it says, please take notice that defendant Imani Green, Dani'S Jackson, will bring her motion to dismiss for hearing in person at 2 p.m. on May 13, 2026, before the Honorable Judge presiding over the civil motion session of Mecklenburg County Superior Court in courtroom 6310, or I assume thereafter as the course of the business will allow. Wait a minute, guess what? If this is going to be in person, which it says it is, on May 13, 2 p.m., and they are giving everyone a courtroom, if it's public, that means people might be able to attend. People might be able to attend and show up there. I wonder if anyone's going to be reporting on this or, attending, like this North Carolina based. And it says, as required, okay. And it says, as required by the court, the following rules are in place. Normal courtroom decorum and dress code still apply. In compliance with North Carolina law, this hearing is open to the public. Yes, the hearing is open to the public. It's going to be next week. And This hearing is being recorded by the clerk of court and will be maintained for purposes of establishing the official record. So it will be recorded. So most likely there will be transcripts. And I will probably try to get the transcripts at least. But I wonder if they're going to do video recording or just transcription. It's May 13, 2026 at 2 p.m. To avoid talking over each other, please wait until the court calls on you to speak. So it's open to the public. You said hit me up. Well, let's see here. It says to avoid talking over each other, please wait until the court calls on you to speak. When it is your turn to speak, please speak slowly and clearly. And respectfully submitted this 4th day of March 2026. So that's that. So let's go to the next document on this list. Hold on. Okay, I think this is one I went over just now. Yeah, when I was downloading some of these, it was a lot of documents, so bear with me, okay? Just a second. Let's see what's here. Let's see what this one says. It says the undersigned counsel, Brian Williams of the law firm of Hidrick, Gardner, Kinchillo, and Garfello, it looks like, LLP, hereby provides notice to the court, all parties in counsel, that he will appear as co-counsel in this action on behalf of defendant Khalil Cook. So, Khalil Cook also has representation. As such, all pleadings, notices, calendars, and other documents should also be made on the undersigned. There we go. Okay, so Khalil Cook also has representation. Let me get some shout outs really quickly. Shout out to Nitty. Thank you so much for joining the backup channel membership. Again, shout out to Nitty for joining the backup channel membership. I appreciate the support. Also, shout out to Cherie. Thank you so much for renewing your membership as well. Yes. Now make sure you only need like the cheapest one on the backup channel. And to be honest, I might actually lower the price. Okay, but yeah. So it depends on, I'm not going to be over here a lot, so you don't need to get the highest package. Well, to be honest, I might be over here a lot because I'm switching back to true crime temporarily, okay? So let's see. Shout out to Judy Coles. Thank you so much for being a member for 21 months. Happy anniversary. Yes, and yes. Avengers Assemble. Yes, and yes. And what I mean by that is I'm going to be talking about true crime, but I'm going to be going back and forth between my main channel and this channel. So both channels will be talking about true crime. Okay. So therefore, the main channel is the main one. And this is just a backup. So you only need the smallest package on this one. Okay. Yeah. No need to get the VIP or the higher price, just the lower price. But I definitely do appreciate the support. Eternity says, this channel was how I met Danny and all of you. Yeah, a lot of people met me on this channel. And to be honest, this is actually one of my favorite channels as far as true crime goes, okay? Now, I will be honest and say that this case right here is a case that really, to be honest, like the outcome, the moment when they said they were not going to press charges and other things were happening, I was just really upset at this, at everything, and the lack of justice and the unfairness. And it's just a lot going on with this, how the world is. And now, even within the latest case, there's Ashley Robinson, another case of someone traveling overseas, and people are seeking answers as to that case as well. Okay. Yeah, but yeah, I actually am interested in true crime. Definitely am. Okay. it just, you have to make sure that when you do true crime, you understand that, you know, sometimes justice takes a long time. It does. It takes a long time. And you can actually get really close to the case. And you can really get really close to the case and feel connected to the case in a way that can, to be honest, when there is a lack of justice, it can really get you down. I'll be honest, okay? Yeah. So anyways, let's go ahead and get to the next document. So hopefully we will be getting some answers with this case. And most importantly, the family, hopefully they will get their answers because they deserve their answers. It was wrong what happened to Shanquella, and Shanquella deserves justice. She does. And I think a lot of us grew close to this story, and we all want justice for Shanquella. And we all are really going hard for justice for Shanquella, okay? I still feel like the FBI in Mexico dropped the ball and on this whole story, but I do feel like the civil case, if they get past the hurdle of this technicality and procedural stuff, I feel like we will get answers. And Dani'S Jackson, we don't need her to get off the hook for technicality and procedural stuff like lack of jurisdiction, personal jurisdiction, or you know, service issues or insufficient process. We don't need her to be able to escape. So hopefully things will go smoothly because she has this motion to dismiss. And sometimes cases are dismissed at this stage because of technicality, not because the person is innocent, not because they're right. It's because of something procedurally wrong happened with the service, with the jurisdiction, or other things to where the case won't get past that point. But hopefully it won't happen that way, because if it's not dismissed next week for one of those issues that she's bringing up, then the case will proceed to where she will have to then answer to the complaint. And once she answers the complaint, she will have to then bring up other defenses and actually go back and forth with the merits. And at that point is when we'll actually get answers or whatever, some more defenses for from Dani'S Jackson as to what she has to really say about what happened in Cabo. We're gonna get to that. I hate when they change these names where I can't really see the actual handle, but I do see little C1. We're going to get to that. And I think it's Khalil Cook or one of the defendants are arguing that they believe that this should be healed in Mexico because that's where it happened. And they feel like just because the concierge is there, the doctor is there, the maids are there, and the paramedics are there. They are saying a lot of people that are involved in this are in Mexico. So how can y'all hold this in North Carolina when it happened in Mexico, and that Mexico is the proper venue? Now y'all remember Dani'S Jackson, now you might agree, she has a warrant out of Mexico. They still have that warrant last time I checked on her. So obviously she's not going to want to argue for it to be in Mexico because she has a warrant there. Now I wish they would have to do it in Mexico, and I wish she would go to Mexico so they could slap the handcuffs on her. Okay. And with that goes into the extradition and why that never happened, why they never extradited her to Mexico so Mexico can handle it. Anyways, let's go ahead and get into this the next document. Hold on. Let me give shout outs real quick. Shout out to Scorpio, says, yes, Miss Danny. Oh, thank you so much for the fan funding. Super Sticker, I appreciate the support. Again, shout out to Scorpio. I appreciate the support. And also fan funding, and sending some virtual roses right back at you. I appreciate it. Also, shout out to Scorpio for gifting memberships. So you're gifting a membership from Scorpio. Please, please, please say thank you for the gifted membership. Also, please put some hearts in the chat to show love to Scorpio for their generosity to get the membership. Put some hearts in the chat, please, everyone. Okay, so let's go to the next document. So I'm curious to know what's going to happen next week. But we're going to get into a little bit more about what she is trying to argue as far as jurisdiction and things like that, Dejanay, okay? Okay, this one is, if I gotta show this because it has information on it. Um, well, I can show a little bit. Let me scroll down a little bit, not the full thing. Oh no, it shows her address. Affidavit of service. Okay, so Dejanay was pretty much saying that the address that they served was not her address. And let me actually show y'all this. But let me make sure no addresses are shown here really quickly first. So she said she does not reside at that address, and that the person that they served, it says substitute service by serving Miss Tammy Gordon as co-resident. Co-resident. So she says that she was not properly served because that she wasn't served to her; it was served to a Tammy Gordon. And she says she does not reside at that address, and it has here that someone served her. Um, it's notarized that she was served. So she's going to argue, of course, improper service. Okay. So let's go to the next document. Now, what will happen if they say, well, is that's not proper service? That doesn't mean that it automatically will dismiss the case for improper service. Sometimes you can argue and say, well, the person is evading. I can't get a hold of this person by regular service. We have tried to serve her different times. We have done our due diligence to try to serve this person. So can we do alternative means and methods of serving this person? So sometimes then they will just, instead of dismissing the case, they will allow for alternative service to serve by email, by posting, or some other alternative method. Okay. So it's not the end all be all for lack of service. Where you might run into an issue is if someone says, you can't hear my case and you cannot tell me, and you cannot like bring me into this case because I'm not in your jurisdiction. I have nothing to do with this jurisdiction. I have not targeted that jurisdiction. So you have no personal jurisdiction over me. So that could be an issue, but that's if she's, somewhere else. Well, we'll see what she's going to argue as far as her jurisdiction goes. Okay. Essentially, she's not arguing about has she harmed Shanquella yet. She's arguing about does this court have the right to hear her case? Has she been properly served? Does the court have jurisdiction over her? Okay. Is what she's arguing now. Let's go to the next document. And now she's saying this Tammy person was served, but I wasn't served. So she wants this dismissed for improper service. Let's go to the next document. And this is Dejanay Jackson, now known as Imani Green. Okay, let's go to the next document. Okay, what's this one right here? So let's look at her brief in support of her motion to dismiss for Dani'S Jackson. Oh wait, how many pages is this? What is this? Oh wow, 61 pages. Dani'S, 61 pages. But of course she wants this dismissed, so I'm not surprised that it's something like 61 pages, okay? So Imani Green's brief in support of her motion to dismiss for insufficient service of process. If this is 61 pages for insufficient service of process, she's really trying to get it dismissed, okay? On procedural things and technicality. Let's see, defendant Imani Green, by and through undersigned counsel and pursuant to local rule 15.6, files a brief in support of her motion to dismiss this action. Pursuant to rules 12B2, 12B4, 12B5, and 12B6 of the Federal Rules of Civil Procedure and North Carolina Rules of Civil Procedure, for lack of personal jurisdiction, insufficient process, insufficient service of process, and failure to state a claim upon which relief may be granted. And she says Salamandra Robinson, which is Shanquella's mother, filed her initial verified complaint in Mecklenburg County Superior Court on October 28, 2024, in which she made various allegations against defendant Green, true allegations against you, and others arising out of alleged incidents that occurred during a trip to Cabo San Lucas, Mexico. Not alleged, bitch, you did it. On or about October 29, 2022, you know what date. On October 29, 2024, numerous summons were issued, including one for defendant Green, aka formerly known as, they put FKA as Dani'S Jackson, listing, let me skip over that address, defendant Green's address, the state court summons. Plaintiff then filed an amended complaint on November 8, 2024. An additional summons for defendant Green was issued on November 8, 2024, listing the same address in Jamestown, North Carolina. Then on November 14, 2024, this matter was removed to the United States District Court for the Western District of North Carolina. Following removal, a summons for defendant Green was issued by the United States District Court for the Western District of North Carolina on December 30th, 2024, listing the same Jamestown, North Carolina address. Despite the case's removal to federal court, plaintiff filed an affidavit of no service with the Mecklenburg County Superior Court on January 7, 2025. Here attached here to as Exhibit D. This affidavit completed by the Guilford County Sheriff's Office indicates that the sheriff attempted to serve defendant Green at the Jamestown, North Carolina address on December 10th, 11th, 17th, and 30th. Additionally, the affidavit states that defendant was not served for the following reason. Defendant does not live at address per current resident. This is because defendant Green moved to Hartford, Connecticut in December 2022. See Declaration of Imani Green attached here too as Exhibit E. Defendant Green has not lived at that Jamestown address since April 2021. See Declaration of Tammy Gordon attached here too. So it looks like she got in touch with that Tammy resident at her past address, and maybe that person has wrote a declaration declaring that maybe that she has resided there now, and that Dani'S doesn't live there. So if she's saying that she lives in Connecticut and she was never served, that could be problematic. However, they could say they did due diligence and try to get alternative service, so the judge might not dismiss it based on that. Now, as far as the personal jurisdiction, we might, it might run into some issues, depending on if they issue her contact with that forum. But the victim lives there though, so I will have to go over this. Okay, we will have to see what they decide on this. An additional federal court summons was issued for defendant Green on January 30th, 2025, listing a new Connecticut address. And then plaintiff retained Reno Investigation Services on April 1st, 2025 for the purpose of surveilling and making service on defendant Green. See Reno Investigation Report here to attach as Exhibit H. On May 7, 2025, plaintiff purportedly made substitute service of defendant Green on Ms. Tammy Gordon at the Jamestown, North Carolina address, utilizing the federal court summons. See alleged affidavit of service attached here too. However, this affidavit of service was not filed with the federal court or served on Ms. Green prior to plaintiff's opposition to defendant Green's motion to dismiss, which was originally filed in federal court on July 15, 2025. Defendant Green filed her pro se answer to plaintiff's amended complaint on June 18, 2025, asserting, among other things, that plaintiff's service of process was improper as she did not reside at the address where she was served. Well, if you already filed an answer to the complaint, how can you still be arguing about service? Argument. Defendant Green's motion to dismiss or failure to make proper service is governed by the federal rules of civil procedure. Maybe she filed an answer at a time she didn't have a lawyer. I don't know. But if you usually when you already file an answer, you kind of, not always, but you sometimes waive service. Arguments. Defendant Green's motion to dismiss for failure to make proper service is governed by the federal rules of civil procedure. Preliminarily, defendant Green's motion to dismiss for failure to make proper service is governed by it's in a heading in the sentence. Once the case has been removed from state court, the federal court applies the federal rules of civil procedure, and the case is treated as though it was were originally commenced in federal court. Here, plaintiff asserts that service was made on defendant Green on May 7, 2025, utilizing the federal court summons issued by the United States District Court for the Western District of North Carolina on December 30th, 2024. Because alleged service on defendant Green was made pursuant to the federal court summons while the matter was pending in federal court, those service efforts must be addressed pursuant to the federal rules of civil procedure, despite the fact that this matter has now been remanded to state court. Plaintiff failed to make proper service or process on defendant Green. A summons must be served with a copy of the complaint. The plaintiff is responsible for having the summons and complaint served within a time allowed by Rule 4M and must furnish the necessary copies to the person who makes service. Hold on one second. If a defendant is not served within 90 days after the complaint is filed, the court on motion on its own, after notice to the plaintiff, must dismiss the action without prejudice against that defendant or order that service be made within a specified time. But if the plaintiff shows good cause for the failure, the court must extend the time for service for an appropriate period. So I'm not going to read all 61 pages, but I will give you the gist of it, okay? So right here, a plaintiff asserts that service was made on defendant Money Green by serving Ms. Tammy Gordon at that old address in Jamestown. Plaintiff further alleges that Ms. Tammy Gordon was a co-resident of defendant Green and that Ms. Gordon confirmed that Money Green was a resident of the home. This statement is objectively false. So she's saying the lady that currently lives there, Tammy Gordon, is not a co-resident, that she does not live there, and she was not properly served. So I'm going to skip over this. And she's pretty much saying here, defendant Green has not resided at that Jamestown address since April 2021, over 4 years before substitute service was purportedly made on her at that location. Defendant Green established another residence in North Carolina after 2023 before moving to Connecticut. Defendant Green then moved out of the state of North Carolina to Connecticut in December 2022. Interesting, but you say you moved out of the state of North Carolina in December to Connecticut in December 2022, but at the time of Shanquella's Unaliver in October 2022, you were living in North Carolina. So at the time of the actual harm, you were living in North Carolina. So you might be out in Connecticut now, but a lot of times, sometimes if you can't like move to a different state and then now say that someone doesn't have jurisdiction over you. At the time when the crime happened, you were still in North Carolina. You just told on yourself. You didn't move to December 2022. Since December 2022, defendant Green changed her bank accounts and other personal affairs to her Connecticut residence. Girl, you trying to escape? You were living in North Carolina in October 2022 when you unalived Shanquella. So North Carolina, in my opinion, does have personal jurisdiction over this claim because you were in North Carolina when this action and harm happened. And then you moved to Connecticut, I guess, to try to flee from that, jurisdiction things. So then they change your bank accounts and other personal affairs, change your name later. She says since December 2022, defendant Green has resided solely in Connecticut, establishing residency in Connecticut. Of course, you're going to try to establish residency somewhere else because you're trying to escape. Establishing residency in Connecticut and maintain employment in Connecticut. So she's trying to say that she doesn't have significant contact with the forum state of North Carolina for them to haul her into this court. At no time following April 2021, the defendant Green reside at that address. Yeah, but you just told yourself you were a North Carolina resident at the time you before moving to Connecticut. At the time of her unaliving, you were under the hold and jurisdiction of North Carolina. Plaintiff was aware of this fact as the affidavit of non-service completed by Guilford County Sheriff's Office on January 7, 2025, indicated that defendant Green did not live at the Jamestown, North Carolina address per the current resident. But the plaintiff admitted in their opposition to defendant Green's motion that private process server Raymond Rayno of Rayno Investigative Services served defendant Green's 2018 Honda Accord parked in the driveway of the Connecticut address. Plaintiff claims that Ms. Gordon informed the process server that Monty Green was a resident of Jamestown, the address. However, this statement is objectively false based on the statements of defendant Green, Ms. Gordon herself in the Guilford County Sheriff's Office. In May 2025, Ms. Gordon told the process server from Rayno Investigations that defendant Green was not a resident of that Jamestown address. And in fact, she had not been a resident since April 2021. Exhibit E. It gives exhibits. We will look at those later. This was consistent with the information Ms. Gordon provided to the Guilford County Sheriff's Office in December 2024, Exhibit C. Further, there is no evidence or allegation that Ms. Gordon was an agent of defendant Green or authorized to accept service on her behalf. Therefore, because defendant Green was not living at that Jamestown address in North Carolina at the time service was purportedly made, this was not defendant Green's dwelling or usual place of abode. As such, plaintiff's purported service on defendant Green via personal service on Tammy Gordon at that Jamestown address was not proper. Without service, the court lacks personal jurisdiction, and therefore the court lacks all jurisdiction to adjudicate that party's right. Whether or not the court has valid subject matter jurisdiction, as such, this matter should be dismissed. No, it should not, because she was still in North Carolina at the time of the Shanquella's unaliving. She didn't move until December 2022, and this happened in October 2022. Yeah. Even if the court should find that service on defendant Green was properly made via Tammy Gordon, plaintiff service on defendant Green was also untimely. In a case that has been removed to federal court, if service was not prior to removal, the plaintiff has the opportunity to make service following removal, consistent with the requirements of Rule 4M of the Federal Rules of Civil Procedure. Therefore, pursuant to Rule 4M, plaintiff had 90 days from November 14, 2024, or until February 12, 2025 to make service on defendant Green. However, plaintiff blatantly ignored this deadline. How can she ignore the deadline when she was attempting to make service? That's not ignoring. First, plaintiff waited until December 30th, 2024 to obtain federal court summons, which listed the North Carolina address. Then 30 days later, on January 30th, 2025, plaintiff obtained the additional federal court summons listing a Connecticut address for defendant Green. Despite obtaining these two summons, plaintiff made no additional efforts to serve defendant Green with process until April 1st, 2025, when plaintiff hired Reno Investigation Services to surveil and make service on defendant Green. So did Reno Investigation complete the service? Yes or no? If they did, then they did. This was already 138 days after the case was removed to federal court, well outside the statutory deadline established by Rule 4M. It wasn't until May 7, 2025 that plaintiff asserted substitute service was effectuated on Miss Tammy at that Jamestown address. This is 174 days after plaintiff's amended complaint was filed, almost double the statutory deadline. As a result, plaintiff service on defendant Green was untimely and improper. And again, without proper service, the court lacks personal jurisdiction over defendant Green, and the matter should be dismissed. Then they go over the statute of limitations. Wait 1 second. Really trying to say that it's past the statute of limitations, past the 90 days for, for service, and it's not due to, and it's due to the plaintiff not taking fast action and initial action, installing and, taking their time. Pretty much they're trying to say to serve the defendant. So this should be dismissed because she was not properly served. She does not live at that Jamestown address. She's not a co-resident of Tammy. That Tammy has sent in a declaration. Now, Tammy, why did you do a declaration for this person? But I guess she asked for a declaration that I have not lived there. Maybe Tammy, if she doesn't live there, I don't know. Some people might think she's living there and, and someone covered for her. I don't know. But the point is, maybe the person, because a lot of people have went to that address, and even some news people went out to that address. So maybe, the person probably wants everyone to know that she's not there. Okay. Just a second. For the reasons stated herein, the undersigned respectfully request the court grant her motion to dismiss pursuant to rules 12B2, 12B4, 12B5, and 12B6 of the Federal Rules of Civil Procedure and North Carolina Rules of Civil Procedure. The lack of personal jurisdiction, insufficient process, and insufficient service process, and failure to state a claim upon which relief may be granted. You don't even go over any 12B6. You mostly discuss the others. 12B6 is a failure to state a claim on which, upon relief to be granted. But I'm sure she probably didn't want to touch on that because touching on those topics will sometimes, to be honest, lead to you having to answer or kind of semi-responding to the allegations against you. So maybe she's hoping the judge will just review it and say, well, this is not really establishing a claim, and dismiss based on their own analysis. So now, okay, it's not that many pages, it goes into exhibits. So let's see the exhibit, I guess, what Tammy had to say about that address. Now, let me actually look up something really quickly too, because I'm curious. Which document is this one? Document number 17. I'm curious about this whole situation about if she was residing in North Carolina at the time of Shanquella's unaliving, that should make it so that she cannot argue about personal jurisdiction because she was residing in that state at that time of the unalive, and she didn't move until 2 months after, almost 2 months after Shanquella was unalive by her. Hold on one second. There's a lot of moving parts to this whole thing. Like, it happened in Mexico. The victim is in resided in North Carolina, and the family. A lot of the couple resided in North Carolina, and then one, I think, he was in resided in Connecticut, but then Dejanae was in North Carolina, but then she moved 2 months after the death. It's a lot to it. Okay, so let's look at this really quickly. Go down here. So right here, she's pretty much just showing exhibits as to service documents and things like this. This is the declaration of Dejanae Jackson. Says, I, Imani Green, formerly known as Dejanae Jackson, being of legal age and duly sworn under penalty of perjury, pursuant to 28 U.S.C. codes, attached and states as follows. I am over the age of 18 years old, suffer no legal disabilities, have personal knowledge of the facts set forth below, and I am competent to testify. I am a current citizen and a resident of Hartford County, Connecticut. So she's really trying to put out there that she's a resident of Hartford, Connecticut, that's where her abode is, her domicile. She's really trying to push that she is not a part of anything North Carolina because she wants to avoid that jurisdiction over her, okay? She says, I have not resided at the Jamestown, North Carolina address since April 2021 when I moved to the Trail Circle, Walkerton, North Carolina. Please see first page of the lease. So, okay, so at the time of Shanquella's unaliving, we unalived her, you were at the Walkertown, North Carolina address, so you were still in North Carolina at the time of her unaliving. Please see first page of the lease attached and incorporate herein as Exhibit A, showing the original lease term from April 2021 to May 2022, which has been redacted to protect my privacy. Of course, your privacy after you unalive Shanquella. Who gives a fuck about your privacy? I relocated to 221 Grandview Terrace, Hartford, Connecticut in December 2022 to escape and to avoid, because you were trying to get out of there. When I moved from North Carolina to live with my grandmother in Connecticut, sure, just it's great timing to move, right? Please see North Carolina residents notice of intent to move out and text message with property management company attached and incorporate herein as Exhibit B, showing lease termination in November 2022 and move out in December 20. This lady, she gets on my nerves. So you unalived Shanquella in October 2022. You terminate your lease from the Walkertown address in November 2022, and then you move out in December 2022. This is an escape. So the judge should not let you off the hook. And she's blending the personal jurisdiction with the service of process. Okay. She says, I have worked various jobs since reestablishing residency in Connecticut in December of 2022. See attached offer letter from my most recent employer dated February 6, 2024. Attached to incorporate herein as Exhibit C, showing the 221 Grandview Terrace, Hartford, Connecticut address which has been redacted to protect my privacy. I also changed my address and residency on my bank accounts to Connecticut. Please see statements from April and May of 2024 attached and incorporate herein as Exhibit D, showing the Grandview Terrace, Hartford, Connecticut address, which has been redacted to protect my privacy. Ms. Tammy Gordon is over the age of 18. However, Ms. Gordon did not have the authority to accept service on my behalf at the Jamestown, North Carolina address. Was not my residence, dwelling, or usual place of abode, and has not been since April 2021. On May 7, 2025, I received a text message from Ms. Gordon regarding some documents she was handed when she went outside. Upon information belief, Ms. Gordon informed that person that the Jamestown residence was not my residence. Well, how in the world does she have your phone number? How is she able to text you? Did you have the same number you did in Cabo? So 3 years after the whole Cabo situation, she has your number, or did you reach out to her or contact her? So she was able to just text you and say regarding some documents. She texted you about documents what she was handed when she was outside. So she has your number, okay. I declare under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. Signed, Imani Green. So this is, I guess, a lease and moving in information for the Walkertown that she moved in, I guess, April 2021 at the Walkertown address. So at the time of Unaliver Shanquella, you were living at the Walkertown address, paying rent of $1,155, I guess. And then once you unalive Shanquella, you terminated your lease in November 2022 and then moved and fled North Carolina to live with your grandma in Connecticut, changing everything and trying to get a different residence because you probably looked up, you know, things and tried to figure out how you can flee. This is residence notice of intent to move out. So yeah, right here, lease contract date. She wanted to move out November 1st, 2022. Now, I don't think anyone really doubts that you were trying to run away and get away and that you moved out and you fled North Carolina. We're not, you know, I don't think anyone believes that you didn't try to. Okay, let me see if I can flip this around. Okay, went back. Pop. So someone messaged her, says Ashlyn Chandler, says, hey there, Dejanae. I am just checking in to see if you are still planning to turn in keys. This is December 5th, 2022. As of now, you are still in possession of the home and we cannot access the home to prepare for a new resident without possession being returned to management. Please touch base with me and let me know what your plan is. Thanks so much. Okay, so you still have possession of the residence on December 5th, 2022. So she's really trying to argue about the service issue because she's really trying to argue service and get this dismissed and she wasn't properly served. But she doesn't go into great detail about the Connecticut address. But yeah, this is the thing right here. You told on yourself. Now, the service thing, you could argue, but most likely the court hopefully the court will not dismiss for improper service and that they will just allow for an extension and due diligence and do alternative service or something else, okay? But yeah, you told on yourself because right here it's showing that you still were a resident of North Carolina and you still have possession of this home domicile, your abode, December 5th, 2022. It says you are still in possession of that home, right? So you unalive Shanquella on October 29th, 2022 in Cabo. So if you are still residing in North Carolina, which this proves, when that harm happened, you unalived her, you cannot act like you're just a person from Connecticut now, and that you have no connection to North Carolina, because the harm happened in the harm happened while you were still a resident of North Carolina. Okay, that's like someone unaliving someone in Tennessee, and then they move to Mexico, and they say, "Well, Tennessee can't do anything to me." Let's be honest. I won't say Mexico. Let's say they move to New York. Usually what would happen is say, okay, you unalive someone in Tennessee. Now we're gonna put a warrant for your arrest or do something, and we're going to find you in New York and bring you back to Tennessee where you committed a crime. Okay? So moving does not change the fact that at the time when this happened, the harm happened, you still resided in North Carolina, where the victim resides, and where you resided as well. Now, the service issue, now that's going to be the fight that's going to happen as far as the service. But at the same time, it probably wasn't smart, which I'm glad you did, to say that the Tammy person texted you that she received mail. Yeah. Yeah, you moved on to the death. So you were a North Carolina resident when it happened. Shanquella was a North Carolina resident when it happened. Her family is in North Carolina. The estate is in North Carolina. And when y'all lied and was calling back to talk about Shanquella, y'all were calling North Carolina when y'all called Shanquella and family. And when y'all returned from Cabo, y'all went to the residence in North Carolina of the mother and lied to the mother about what happened in Cabo at her North Carolina home. All of this is a part of it. So now you can't just move to Connecticut now like you have no ties to you can't move to Connecticut and say you have no ties to North Carolina. Now, I will say there's another person in this case, I think it's Khalil, who probably has the best argument. And I hate to say that, but the best argument he has is that this happened in Mexico and there are missing people. There are missing people in this case. The doctor, concierge, the manager of the concierge, the maid. There are other people, even the drivers, the chef. Without those people, there's not going to be a full story, right? And now sometimes that requires joinder, where you say that other people should be joined into this case. And then also there's going to be jurisdiction. You say, well, this happened in Mexico and it's the best place for it because everyone that is there. Here's the thing. Do y'all really think that Dejanae, who has a warrant in Mexico, is going to go back to Mexico and face trial there, knowing that as soon as she steps her manly ass on that in Mexico, she's going to be arrested and apprehended? And that will be great. So in my opinion, they're trying to get it dismissed by saying that she'll be healed in Mexico. So, and with no intentions and no plans of actually going to Mexico, because that would require extradition. And they already know Most people, the LPR said no one has really extradited even Dejeuner. So they're hoping that it would be dismissed based on some sort of jurisdictional issue, and then the case would be gone or dismissed in the United States, and then what? Now, to be honest, I will have to see and check for myself. If they did say, okay, Mexico, I don't know how that will work for civil cases. As far as in the United States, when things like this happen, it could be transferred, just like it was transferred from the state court of North Carolina to the federal court, and then it was transferred back to North Carolina, the state. Cases can be transferred within the United States. Now, as far as outside of the United States, I don't know how that will work. I'll be honest. I'll have to check that and research that. Okay. But as far as the jurisdiction goes, right here, the plaintiffs can argue that she was still, not only did she unalive Shanquella, who's a resident of North Carolina, but she was a resident at the time of Shanquella's death in North Carolina. And on top of that, when she returned from Cabo, she went to North Carolina. She fled to North Carolina, visited the home of Shanquella's family, and still lived there for another month and a half before she fled out of North Carolina. So that's not a good argument. The best argument she has so far is lack of service, but I don't think that the judge is going to let her off the hook because of the service issue, because clearly the Tammy person texted her, letting her know that she received her mail. She will serve things. They're in contact, and I don't think that will fly, but we will see. But that is her best argument so far, is the service. But these days, a lot of times with service, they give more times, they give extensions, and they also allow for alternative service. So a lot of times they don't dismiss because of service these days, I'll be honest, okay? Yes, and don't forget, like I said, when they came back, they went to Salamandra Robinson's home, Shanquella's mother, and they lied to her face about what happened to alcohol poisoning. Remember, the crime is not just unaliving Shanquella. The crime is also that when you returned from Cabo unaliving her, you lied. So after the fact, the concealment, the act of concealing the crime and lying about the crime happened after you return, and that happened in North Carolina. So not everything happened in Mexico. Some things, cover up stuff, concealment, also happened when they called to North Carolina on the phone. That communication to that connected them to North Carolina. And then on top of that, when they flew back to North Carolina, they went to a residence and lied about what happened and said, alcohol poisoning, they were not fighting and things like that. So that changes where all harms do not occur in Mexico. Some occur in Mexico and some actually occur after the fact and during the fact, electronically and also otherwise via North Carolina. So the plaintiff Salamandra can really argue it's not just about the physical assault that happened in Mexico. It is also the author of the death. There is the concealment and the harm and the emotional distress and things that happen at the mother's estate in North Carolina. So the jurisdiction, her trying to argue that North Carolina doesn't have jurisdiction over her, is not really going to hold, I don't believe. That's just my opinion now, let me say. But the service issue is probably the best angle she has now. But in 2026, a lot of times people prefer not to dismiss over service if they can help it, especially cases like this where there has been shown due diligence of trying to get some sort of service. A lot of times they will extend it and give alternative service methods. And then she briefly touches the Connecticut service and some sort of investigator, and then she really doesn't go into detail about how they committed whether they completed service or not. Let me just flip this over. So this is some sort of okay, you said you were gonna redact this, girl, and I thought you did, but you didn't fully redact it because your address was on top. Unless you redacted it with whiteout. It says, congratulations and thank you for considering blank as your future employer. I am pleased to confirm blank offer of employment to you for the position of hybrid blank coordinator. Call center in the blank. Including this letter are all aspects of our employment offer to you. Boo! Now, the reason she doesn't want everyone to know her new employment because she already knows people will call and report her job, right? So this is showing that she had got a new job in Connecticut. So she's really trying to distance herself from North Carolina. I don't live there. I don't have a bank there. I don't do nothing in North Carolina. You cannot make me come to you don't have jurisdiction over me, North Carolina, but that's not going to work. Her best argument, again, is the service issue. Anyway, shout out to Black Butterfly. Says, hey, Danny, I'm in the house. Oh, thank you so much, Shell. I appreciate it. Again, shout out to you. I appreciate the support. Fan Funding, shout out to Cheyenne. Happy 28-month anniversary. Yes, I've been just forever. Oh, thank you so much. I appreciate it. Happy anniversary. Also, happy 27-month anniversary to Lisa. Yes. I appreciate the support. Again, shout out to you. And everybody else, remember, support my channel for free just by what? Hitting that like button. No listening to those. Hi, Danny. Hey. Watching everything is in the building. Hello, Patty, Howard. Hey. Sandy here. Hey, everybody. Some people I haven't seen in a while, but I know it's because I haven't been on this channel. But I plan to be over here more. Okay. Let's see. Exactly like little. Okay. And I think I saw Lilac here earlier. Shout out to you, girl. Eternity says you don't believe that she moved. I believe that whoever the lady is, Tammy, it's just something a little weird about the Tammy person. Okay. I won't be surprised if there's some connection between her and the Tammy lady, and she texted her and said that stuff was get given to her and things like that. Kay is in the building. So let's go ahead and continue. So this is a job offer. And it says, including this letter are all aspects of our employment offer to you. We look forward to you starting on March 11, 2024 to help us deliver on our mission. This is a target and will be confirmed upon successful completion of your pre-employment screening. Your recruiter and our service advisor will be in close contact with you regarding your start date as it approaches. What blank offers you. As part of our team, you will be rewarded and recognized for your performance in an environment that will challenge you and give you clear direction on what it takes to succeed in your role, as well as provide development for other roles you may be interested in. Your financial compensation may be the first thing you consider, and we are excited to share what we offer goes beyond to support your whole well-being. Your base compensation will be blank per hour, expected annual salary blank, based on an anticipated schedule, 40 hours per week. Your overtime rate will be 1.5 times the hourly salary rate. Any future increases will be based on blank compensation program and your performance. You are eligible to participate in the blank in 2024 to align with our cultural value of performance. Link is an annual performance-based program. Therefore, top performers are rewarded when the business meets its goals. However, there is no guarantee that an incentive payment will be made. Click blank to learn more about the blank. You will also be able to reference these plan details within our onboarding tool. So she redacted this because she doesn't want anyone to know where she's working. And it goes into more. I'm not going to read this entire thing. But to be honest, your contributions will be invested in a target date investment based on your date of birth. Blank and its family of companies are committed to helping employees, whether you are just beginning your career, near retirement age, or somewhere in between, participating in a 401k plan. To be honest, a lot of times people think that this right here will stop them or stop people from figuring out where they work. But sometimes a lot of these are cookie cutter templates where they send these out to a lot of people. And it says for the position of hybrid blank coordinator, call center in the, do y'all know that this is like, girl, the fact that you posted this, I probably could figure out where this is at because it gives too many details. It does. I'm not saying I will do that. I'm just saying that this whole letter, you know, someone could just look through to find bits and pieces to where this letter could probably lead to. But anyways, so let's go to the next document. Hold on 1 second. I'm just gonna copy this because I need it later. Not saying why. I'm just gonna make sure I copy this page. Hold on. Let's go continue. Exhibit D. What is this? Bank of America, she's really trying to establish that she's has 100% moved to Connecticut and has no ties to North Carolina, is what she's trying to show, or prove, should I say. So she puts the Connecticut address and says she has a bank there. So if you say that I plan to stay in Connecticut, I live there, I work there, I have a bank there, everything is Connecticut, I am a Connecticut resident, then, you know, you can't do anything to me if you're in North Carolina. That's not going to work. I'm not going to go over it again, but I went over all the details. That's not going to fly. But again, court is next week, so we will see what they decide. But I don't feel that the judge will obviously, in my opinion, I don't think that will work about the whole Connecticut thing. The only thing she has to really argue is the lack of service. So now we're getting to the declaration of Tammy. Now, Tammy is the one that probably wrote her this declaration to try to say, you know, she resides at the address and not Dejanae. But let's listen to see what Tammy had to say. So Tammy says, I, Tammy, being of legal age and duly sworn under penalty of perjury pursuant to gives the statute, attest and state as follows. I am over the age of 18 years old, suffer no legal disabilities, have personal knowledge of the facts set forth below, and I am competent to testify. I am a current citizen and resident of Hartford County, Connecticut. Ah, Tammy, you messed up. This is the same thing that Dejanae put, but you're supposed to edit it. You're supposed to edit it for North Carolina. Hello? That's what happens when you use the same thing as someone else. Like, I could tell that you use the same template. So then she goes on to say, I reside at that Jamestown, North Carolina address. But she messed up because she just said resident of Connecticut, okay? See right there, she says Hartford, Connecticut. That's supposed to be for Dejanae, not her. So I do believe that they know each other, okay? And text each other. It says, over 4 years ago, Imani Green resided with me. See there, y'all need to stop. Listen, she says, over 4 years ago, Imani Green resided with me at the Jamestown, North Carolina address. You see what I'm saying? Y'all messed up. See, I knew y'all had to know each other. So now when the person said there's a co-resident, this is now where it's coming from. It says, oh, 4 years ago, she resided with you at that address. Imani Green has not resided at the address, though, since April 2021 when she moved into an apartment in Walkertown, North Carolina. On or about May 7, 2025, I was outside my home, North Carolina, when I was approached by a gentleman asking me if I knew Imani Green. I replied that I did. The same gentleman asked me if Imani Green resided at the Jamestown, North Carolina. I informed the gentleman that she did not. After I informed the gentleman that Imani Green did not reside at the address, he left the premises. The same gentleman returned approximately 2 hours later and handed me a packet of legal papers for Imani Green. I declare on the penalty of perjury under the laws of the United States of America that the foregoing is true and correct. Just a second. So they tried to serve her in North Carolina and through Tammy, who knows her. And then she admits that Tammy actually texted her and let her know that she was giving papers for her. And then she says later that they tried to serve her in Connecticut. So with that being said, that means that they did try their best to serve her at these two addresses in two different states. So that's not like negligence, like they refused or they wasn't even trying to serve her as she was trying to say or allude to. So they were making real efforts to try to serve her. So, in my opinion, I feel like Dejanay is trying to argue, like you all knew that I wasn't in North Carolina. I knew that wasn't me at the. I don't reside at the Tammy address with Tammy, and y'all knew I had moved to Connecticut because y'all hired people in Connecticut to serve me. But yet and still, you still went back and substituted service, and you still went back to try to serve Tammy instead of trying to serve me in Connecticut. But then, of course, they can argue, well, we saw your car outside of a Connecticut address and residence, and we feel like you're trying to evade service and things like that. So they can say that we attempted service in Connecticut and North Carolina. And they're probably going to say that you had actual notice because you filed an answer within a short amount of time To be honest, before you hired a lawyer, you already had answered this. I think you're forgetting that you already answered before you hired a lawyer. And by answering a complaint, sometimes you waive, not always, but you sometimes waive service. You're showing that you was, there is a difference between filing a motion to dismiss where you're trying to argue jurisdiction and service, and filing an answer. An answer is when you're trying to reply whether something is true or not, or offer certain defenses. Yet and still, I will say that that's her biggest argument is service. And that's why she's still going, that's why it's 61 pages, because she feels like service is going to get her off the hook. That it's going to get her off the hook and avoid her having to answer for harming Shanquella by saying that she wasn't properly served. Now, this one right here actually has summons. This actually has the Connecticut address right here for summons to serve her in Connecticut. And she's saying, I guess, that they kept on trying to focus on North Carolina address instead of the Connecticut one. Okay, hold on. So this service right here, it says, per your direction, Reno Investigative Services was requested to conduct a located investigation for both above listed subjects in an attempt to verify their current home address. And that's Malik Dyer and Imani Green, Dejanae Jackson. Remember, Malik and Dejanae are the ones that were kind of based out of Connecticut, where people know they have a lot of family in Connecticut. So people were not sure if they were trying to be, in Connecticut or North Carolina on the Unaliver of Shanquella, right? It says, once located, a surveillance for each subject was requested in order to follow them to a public location in which they can then each be served with the provided federal lawsuit documents recorded while being served. Upon receipt of the investigation, Investigator Reno began the investigation by running a series of computer database pulls in an attempt to locate both the current verified address for each subject. Investigator Reno also ran motor vehicle database searches for each subject in an attempt to verify the current registered vehicles for each subject. The results of those searches are included in this report. And they gave Dejanae Jackson, Imani Green, and gave a 2018 Honda Accord. I want to get all into those details. And then it gave the next thing, a gray Infinity, I guess, for Malik Dyer, 2014 gray Infinity sedan. And it says the results of that investigation. It says on April 7th, 2025 at approximately 12 p.m., Investigator Reno departed for Hartford, Connecticut. At approximately 12:30 p.m., Investigator Reno arrived in the vicinity of the verified address for Imani Green, Dejanae Jackson, and it gave its address. Upon arrival, the residence was observed as a two-family white residence with black trim. A detached single-bay garage was located behind the residence with a driveway on the right side of the property. Upon driving past the residence, several vehicles were observed parked in the driveway. However, the subjects confirmed 2018 gray Honda Accord bearing a North Carolina license plate was not present. Investigator Reno established a surveillance position and awaited the subject's return. At approximately 1 p.m., the subject had not returned to the residence. Surveillance continued. At approximately 2 p.m., the subject had not returned to the residence. Due to the lack of activity from the subject, Investigator Reno then departed for the address located for the second subject, Malik Dyer. At approximately 2:20 p.m., Investigator Reno arrived in the vicinity of the subject, Malik Dyer's residence, and it gave the address. Upon arrival, the residence was observed as a single-family tan shingle residence with no garage. Located to the right of the residence was a short driveway with two vehicles present. Neither vehicle was the subject's verified vehicle of a 2014 gray Infinity. bearing a Connecticut license plate. Investigator Reno established a surveillance position with the view of the residents awaiting the subject's arrival. At approximately 3 p.m., the subject had not yet returned to residence. Surveillance continued. At approximately 4 p.m., the subject had not returned to residence. Surveillance continued. At approximately 5 p.m., at approximately 5 p.m., due to neither subject being observed on this date, the surveillance investigation was discontinued for the day. At approximately 5:30 p.m., investigator Reno arrived at the home office. And then it says on April 11, 2025, at approximately 1 p.m., investigator Reno departed for Hartford, Connecticut. At approximately 1:30 p.m., investigator Reno arrived in the vicinity of the verified address for Monty Green, designated Jackson. Upon arrival, the residence was observed as a two-family white residence with black trim. A detached single-bay garage was located behind the residence with a driveway on the right side of the property. Upon driving past the residence, several vehicles were observed, but not her vehicle. This looks like it's repeating. It's a different date, but it's like the same information. Hold on. So it's just different days going over the same information. No, they're not finding her, okay? Surveillance, sometimes, some days there's nothing going to be happening. They're just going to report the same information, like what's observed, same vehicles outside, etc. On April 13, 2025, after several attempts to locate the motor vehicles of each subject at their respective addresses to no avail, investigator Reno then ran a license plate capture program for each vehicle. And doing so, it showed that subject Imani Green frequently travels back and forth between Connecticut and North Carolina, with the last captured location and date of her vehicle being on November 1st, 2024 in Windsor, Connecticut on I-91. With that information, it could not be verified that she was currently in the state of Connecticut. Wow. So, child, what they kind of system they got here? They were able to track her through some sort of system and show that she had been traveling back and forth to So, girl, you're supposed to be completely in Connecticut, but they keep on showing that you're back and forth between Connecticut, and North Carolina. You're going back and forth. Investigator Reno then ran the same search on a motor vehicle being driven by Dyer Malik. It says, in doing so, it was observed that he also takes trips between Connecticut and North Carolina frequently. The last observation of his vehicle was on September 25th, 2024 in Bloomfield, Connecticut. With that information, it could not be verified that she was currently in the state of Connecticut. And that was, by the way, talking about Malik, which is a male. On April 14, 2025, at approximately 5:30 p.m., investigator Reno departed for Hartford, Connecticut. At approximately 6 p.m., investigator Reno arrived at the subject's address located at 221 Grandview. Ooh, my bad. Okay. The subject's gray Honda Accord bearing a North Carolina license plate was observed parked in the driveway with several other vehicles. Investigator Reno established a surveillance position with the view of the end of the driveway. Ooh, child, not you supposed to be all in Connecticut and they find you in North Carolina. At approximately 7 a.m., there has been no activity from the subject. Surveillance continued. At approximately 8 a.m., there has been no activity from the subject. Surveillance continued. But at approximately 9 a.m., the subject's vehicle was observed as it was pulling out of the driveway. The vehicle was then observed as it parked on Grandview Terrace. A black male then exited from the vehicle and entered the front door of the residence. A moment later, a brown colored sedan Honda Accord with CT license plates pulled out of the driveway and parked on the street. The same black male then exited the vehicle and boarded the subject's vehicle. He then pulled the vehicle back into the driveway, boarded the other Honda, and departed from the area. Surveillance continued. At approximately 10 a.m., the subject's vehicle remained present. No activity was observed. Surveillance continued. At approximately 11 a.m., the subject's vehicle remained present. No activity was observed. And approximately 12 p.m., due to the lack of activity from the subject, but now knowing the subject does reside at this address, Investigator Reno terminated investigation for this date. At approximately 12:30 p.m., Investigator Reno arrived at the home office. Ooh. Child, see, I could be no investigator. Good night, Eternity. I can be an investigator. You have to keep on like hours and hours and hours of surveillance. At approximately 6:30 a.m., Investigator Reno arrived at the subject's address in Hartford, Connecticut. The subject's gray Honda Accord bearing a North Carolina license plate was observed parked in the driveway with several other vehicles. Investigator Reno established a surveillance position with a view of the driveway. So I'm not going to read all of this. It says no. It says surveillance continued. And it says no. Later at the home office, Investigator Reno provided client with an update of the status of the investigation. It was requested to continue to attempt to serve both parties and to now serve them any way possible, as opposed to following them to a public location only and serving them at that location. Investigator Reno requested additional retainers for each party. Investigator Reno was then requested to provide a report today in order to receive authorization for additional retainers. Just a second. Let's go back to the Tammy service document. Plaintiff's opposition to defendant's Imani Dream motion to dismiss. Just a second. So yes, that's her goal, is to try to get dismissed due to improper service. Okay. Hold on one second. Now, most likely, I'm probably just gonna update today on Shanquella, and then I'll update in my next live on the next two cases, okay? Because it's already been 2 hours. Just a second. So, okay, so let's go over the last few documents for Shanquella, and like I said, I'm praying that next week when they have this hearing for a motion to dismiss, that is not dismissed because of service, and that there's an extension for service, or there is it's considered sufficient service already. Okay, most likely they're probably gonna say that she had notice, that she has already filed an answer to the complaint, well, at least the original complaint, that she's responding, that she has a sufficient notice. Okay, so most likely I don't think that the judge will dismiss this case for that. However, sometimes some judges are sticklers. They're sticklers, and they are by the book, that if they feel like a certain amount of time has elapsed, not elapsed, but lapsed, and there hasn't been service with that 4 a.m. and within the 90 days or due diligence, they probably will dismiss. But it looks like to me, they hired a private investigator for the Connecticut, and that person did a lot of surveillance. And then they also had North Carolina, where Tammy did get the information to Imani and said that, she had lived with her before. So, so I don't think this will be dismissed because of that, but we don't know. Hold on one second. So let me see something about that one thing real quick. Interesting. Wait one second, y'all. I'm looking at this really quick. So yeah, let me show y'all this real quick. So let's go back to that offer letter. Okay. Where is the offer letter? Now she's obviously redacting it because most likely she's probably still employed there. And I don't care. Yeah. I'm just saying this is a coincidence. Where's the offer letter at? Okay, pay attention to this right here. You see February 6, 2024, and it has the address, and then it says, Dear Imani. And then at the very top, it's redacted with the black redaction. So let me take this comment down real quick. Now it says, congratulations and thank you for considering. It has it blanked out. And then it also says, I am pleased to confirm, and then it has it blanked out. So let me show y'all this. Look at this document from United Health Group, and it has a date at the very top. Dear Jennifer, another person, congratulations and thank you for considering United Health Group. And then it says, what United Health Group offers you as a part of our team, you'll be rewarded and recognized for the performance in an environment that will challenge you and give you. And then going back to Dani'S, and right here, it goes down to right here, what blank offers you. As a part of our team, you'll be rewarded and recognized for your performance in an environment that will challenge you and give you clear direction. And then right here it says, your base compensation will be blank per hour expected annual salary. And things like that. So this exact language. And then right here, if you go down, it says, you are eligible to participate in the blank. Now, if you go to here for the sample, it says you are eligible to participate in the OTH incentive plan. And then right here, it says financial fitness. Then go back to Dani'S document that she redacted, and it says financial fitness. So there's no point in redacting things in the age of internet. When my advice, if you get an offer letter from a job, they give everyone the same offer letter. Besides, they change certain things to personalize it, such as your salary and maybe the call center location or whatever else, certain things to make it more personalized. But ultimately, the same language is going to be sent to everybody. They're not going to write you a type up with you a letter and hundreds of other people with different letters. Y'all gonna get the same template, okay? Now, I hate to be this person, but I am gonna be this person. Sometimes I don't really, for someone like her that's trying to prove that she's in Connecticut and lives in Connecticut, how do we even know that she got this job and she got offered this job or she's working at that job? How do we even know that's true? Because I've been in this YouTube for so long that some people actually doctor up receipts and make up documents and they make up stuff. How do we know she didn't take this person's letter and then change it up for herself? I'm not saying she did, but y'all listen, if you know and you follow the sectors I'm in, I don't put nothing past nobody. But if she does work here and she's redacting because she's trying to hide her new job, then hey, this is her new job. So if you go back to this document that shows where it's at, it says automatic enrollment makes it simple. In general, newly hired employees are those who become eligible for the plan will be automatically enrolled. That's the template. And then this is hers. Let's scroll down and see if she has the same thing. And here it is, the same thing. In general, newly hired employees are those who become eligible for the plan will be automatically enrolled. I hate to say this, break it to you, but it looks like you've been popped as far as what job that is. Okay. Hold on. United Health Group. Yep. Okay, so let's go to the next thing. Let's go to the next document. And like I said, I know in my title I have, you know, those two. But I want to make sure that I do those separately from Shanquella's case for today, okay? Because to be honest, I'm tired. Okay. But hold on a second. But most likely, to be honest, for the Mr. Prada case, I updated that on my main channel. My main channel is where I talked about the Cara and Mr. Prada. So most likely tomorrow in my live, I'll talk about those two on my main channel. So make sure you subscribe to Danny Robertson because I'll talk about Mr. Prada and the Cara on my main channel, okay? Tomorrow. But let's go. But there's like 2 more documents for Shanquella, so let's go ahead and review those. Just a second. Okay, this one right here, I'm not going to show. There's too many addresses, but it's just like an affidavit of service. And to be honest, I think I went over this already for a lease that she was already served, a lease, okay? So most people in this whole thing have been served already. So the family has served these people and they have lawyered up and they are responding one by one. They have responded, okay? As far as trying to get it dismissed, that is. Okay, let's see what Khalil Cook had to say. I think Khalil Cook is the one trying to get this sent over to Mexico. So let's see what Khalil Cook had to say right here. So now, Dejanae, if you're still working at that job that you redact and try to hide, now I know where you work. Ooh. Defending Khalil Cook, buying through his undersigned counsel and pursuant to moves the court to stay plaintiff's amended complaint and respectfully states as follows. A stay of plaintiff's amended complaint is warranted because a foreign jurisdiction is the proper venue for resolving the parties' dispute, and allowing this action to proceed in North Carolina would be inefficient, inconvenient, unreasonable, unfair, and contrary to the interests of justice. A stay is particularly appropriate where, as here, The dispute is centered in a foreign jurisdiction. The dispute involves a significant application of foreign tort laws. A number of witnesses are located in the foreign jurisdiction, and the operative events occur outside North Carolina. Now, what I have to say to that, I do feel that other people need to be brought into this case, but I honestly need to do my research on how this works because this is international things as well. The doctor, the concierge, the maid, the manager of the concierge, the Cabo Villas, there's a number of people that should be added to this case. But they are all, this is most, besides Cabo Villas, the villa itself, are in Mexico. However, I'm not stupid as well because, let me look this up. How would that work? Because they can't even extradite, they can't even get themselves together to extradite Dani'S to Mexico when she has a warrant there. So what can they really do? Because if it was transferred to Mexico, or they said Mexico is a proper venue, how can they get these United States citizens over to Mexico to be tried? They are not going to willingly go over there and travel there. Obviously, why would they? Because as soon as they step foot in Mexico, you know, Mexico might finally do something as far as Dani'S having a warrant there already. So the case would go cold if they transfer to Mexico, in my opinion, unless there's a way to say, you know, this is a civil case, by the way, not criminal. So how can you force them to go to Mexico to be tried there? Let me Google this real quick. My bad, because I don't know. This is international, but I don't know. I'll tell you, I don't know. Okay. And what document is this? This is the one I'm talking about with Khalil. So let me see right here. Let me read this real quick. And he says, a state is particularly appropriate where, as here, the dispute is centered on a foreign jurisdiction. The dispute involves the significant application of foreign tort laws. A number of witnesses are located in a foreign jurisdiction, and the operative events occur outside North Carolina. Well, here's the thing, Mr. Cook. Some stuff occurred in North Carolina because y'all went back to North Carolina to her mother's house and y'all lied in her mother's face in North Carolina. So some concealment happened there. Y'all contacted North Carolina to lie. The victim and a lot of y'all, including you, reside in North Carolina. Now, I do get your point that a lot of others are in Mexico, and maybe they might do two cases, one in Mexico against those people in Mexico and one in the United States against y'all. Okay, hold on a second. Defendant Cook further incorporates by reference any arguments made in any memorandum of law tendered to the court in advance of the hearing on this motion, and all arguments defendant Cook may make at the hearing on this motion. Wherefore, defendant Cook respectfully requests the court to stay plaintiff's amended complaint and grant defendant Cook such other reliefs as the court deems appropriate. So he's asking for a stay. So this obviously can't just be transferred because this is outside the United States. My thing is, I don't understand. So maybe he's consenting to jurisdiction in Mexico, like he's consenting. So, I consent to Mexico, but I don't understand how that can really work, to be honest. If you're consented to Mexico, why can't you just consent to here too? Unless you feel like, to be honest, maybe he feels like the doctor and other people are key witnesses to this whole case. And if I were being tried, I probably would want all the people involved to be under one court case, because that way the doctor has a lot of answers, the paramedics have answers, the maid has answers. Without those people there are in the case at the same time, it are under the same case being sued, it kind of can, he's arguing it could be prejudicial or unfair. At the same time, how can the family get the people from Mexico to be in the United States court and the people in the United States to be in the Mexican court? So how can they do both? That's going to be hard. So to be honest, in this case, they might have to do 2 separate lawsuits. And now, as far as the criminal stuff, as the warrant goes, we already had went over this like a bunch of times before. We don't know why they're refusing to do an extradition. Like if the FBI is not going to actually follow through and press charges, and Mexico says we already put a warrant for Dani'S arrest, then why can't the United States just extradite Dani'S Jackson to Mexico and let them deal with it? They refuse to do so. So it's just weird. Now, one thing that can possibly happen is, and to be honest, that's a good point about her changing her name. The warrant over there needs to update to her name. I'm sure they probably still have it as Dani'S Jackson, but it needs to be updated to Imani Green. So, to be honest, I might contact them myself to see if they can update that. So, and to be honest, it's not going to really change matters. It's just paper. By that, I mean, they still need to extradite her before any warrant can take place. It's just the principle of the fact that if her name is not on it, it'd be great if her name was updated to it. But yeah, I don't think they can be physically forced to go to Mexico by the North Carolina judge. So the asking for a stay, the judge can only pause the North Carolina case. And, but essentially, since they cannot be forced over there, they all would have to consent to the jurisdiction of Mexico. And I don't see them all consenting to the jurisdiction of Mexico. I don't. And to be honest, from a defense point of view, why would they? Like, what defense or defendant would consent to the jurisdiction of an international forum? Why would you do that? You would actually try to fight the one you're in, and you also not want to be, consent to. I would not consent to a jurisdiction. I'll be honest. You're consenting that someone's going to have rights over you to haul you into court. So he pretty much wants them to pause and stall and just put a pause on the North Carolina case and kind of tell the mother to pursue this in Mexico. And that would be annoying because they already started in the state court. It got moved to the federal court, then back to the state court. Now Khalil is trying to get it sent to Mexico. So anyways, what do y'all think about that? This is where it gets complicated, because the judge can either decide to keep this case and continue in this case in North Carolina, or the judge can listen to Khalil and say, you know what, you're right. A lot of witnesses and a lot of people and a lot of facts and a lot of things about this case is in Mexico. So Mexico is the proper venue and the forum for this case to be healed. At the same time, is that going to be fair to the plaintiff when a lot of these people are not a consent or participate in the process of being sued in Mexico? So there's a lot. So we have to understand that we want justice for Shanquella, but when it comes to legal stuff, it gets very complicated, right? What do I want to happen, or what do you want to happen? I would love for things to happen in Mexico and all of them to go to Mexico, because I feel like Mexico will lock these motherfuckers up. That's what I feel, that Mexico will lock them up if they were extradited, but the United States is not really extraditing Dani'S when she has a warrant there. So in my opinion, I would rather for the case, to be honest, to stay here. Stay in. I think they should do 2 lawsuits, one in Mexico and one here. But I don't even know. It might be too late in Mexico, because there are sometimes a statute of limitations, and this happened in 2022, and they barely made the statute of limitations for United States. So maybe in Mexico, it might be past the statute of limitations to bring certain claims. I don't know. I'll have to research it, right? But I think they only had like 1 year, and they did it like on the date for the United States. So they barely made it. Watch Me Saying says Mexico won't lock them up. Well, here's the thing. Mexico actually issued a warrant for Dani'S Jackson's arrest. It might have been just a thing just to silence people or appease people, but the point is they at least made it, did a warrant for her arrest, issued one. So that's one thing, that United States hasn't issued a warrant. They haven't done anything at all. So I feel like if Dani'S went over there, that they would actually arrest her. I do believe that. Especially when pressure is put on them. Because when pressure was put on them before, they issued a warrant for her arrest. Now, do I believe that they would probably arrest everyone? No, because they didn't issue a warrant for everyone, but they did for her. Okay, so let's go to the next document. I'm not trying to hold y'all here all day, but I'm pretty much just trying to give a complete update on all the documents, because I want to make sure I did it, because next week on the 13th at 2 p.m. there's a court hearing, and it's open to the public for those in North Carolina. So hopefully some people that's in North Carolina base will attend the hearing and give updates if possible. So we will see what's going to happen. And for Dani'S Jackson, just pray that she does not get off on being able to say that she wasn't properly served, because that's going to be the big issue. Her saying that she's not a resident of North Carolina, that's not going to work at all, in my opinion. I'm not a lawyer. I'm just saying I don't think it's going to work, because she was residing in North Carolina when, at the time of Shanquella's unaliving, and she flew back there, and I went over there already. So she still already has significant connections to that forum at the time of the Shanquella's unaliving. So let's go to the next document. Did I go over this one already? Okay, so this is from Khalil Cook again. Defendant Khalil Cook, by and through his undersigned counsel, files his memorandum in support of his motion to stay this action pursuant to, and it says, statement of the case. Plaintiff initially filed this action in North Carolina State Court, Mecklenburg County Superior Court on October 28, 2024. Former co-defendants, okay, so it was 2024. So I guess they probably had 2 years. 2 years from the date of her death, so they barely made it. So I don't know the statute of limitations for bringing like a wrongful death case in Mexico. Let me see. Let me Google it real quick. Let's see, statute of limitations for, let's say, wrongful death case in Mexico. And their time could have passed for the civil case because they were trying to wait for the criminal case to have some results. But when they didn't have any results, they had to hurry and quickly file the civil case before it was too late and pass the statute of limitations. It looks like it's coming back, but it's like 2 years for Mexico too. So we have to think about it this way. One Mexico litigation guide says the general limitation period is often 10 years, but certain civil liability matters are an exception with a 2-year period. And if it's 2 years, that's problematic. If it's 10 years, that's good. But if it's 2 years, it's already going to be past the 2 years for Mexico. And we have to be careful because people can be sneaky. Khalil could know, or they could already know, the attorneys could know that it's already past the statute of limitations to bring this claim in Mexico. They can say, oh, Mexico is a proper form. We should do it in Mexico. And then the family, you know, can find out that it's too late to try it in Mexico because it's past the statute of limitations. So it's not a good idea to stay in Mexico. So you have to be careful when people try to recommend something. Check the statute of limitations and see if it's too late to bring a claim in that form. Because if you try to, you know, bring it and then say, okay, well, you can't. It's time barred, right? So Mexico might not even be an option right now, but that's for wrongful death. It could also be other options you can sue for, as far as civilly. Okay, so I would say that this case needs to stay in United States and not worry about Mexico unless it's going to be criminal, because if you try to transfer to Mexico, not transfer, but like try it in Mexico, you might run across time bars or statute of limitations where they could say it's too late and your whole case could be dismissed because you filed too late. And she was unalived in October 2022. Okay, so it might be Khalil could be being sneaky and wanting to say Mexico when he could probably know that Mexico is too late. Also, during the pendency of this action in federal court, defendant Cook and co-defendants Elise Hyatt and Winter Donovan moved to have the case dismissed based on form non-convenience. The court, however, never ruled on their motion, and instead, on January 28, 2026, United States District Court Judge Max O. Cogburn Jr. remanded this matter back to this court based on lack of subject matter jurisdiction. Defendant Khalil Cook now essentially renews his previously filed motion in federal court and moves to have this court stay this case pursuant to as a foreign jurisdiction is the proper venue for resolving the dispute. No. We're not going to say a foreign jurisdiction and send this back to Mexico if it's too late to file to Mexico. We're not going to fall for that. Well, hopefully, you know. Plaintiff's amended complaint alleges various legal theories against bystander Khalil Cook arising out of a fight between two of his travel companions on a trip. Oh, see, this is the part where it gets interesting, to where we need to get past the motion to dismiss stage for technicalities and procedural things like failure to state a claim or improper service or insufficient service, and jurisdictional issues like personal jurisdiction. Get past that point to get to the meat and potatoes, because now guess what? Khalil Cook, in his filing, he says plaintiff's amended complaint alleges various legal theories against bystander. He's saying, look, I'm a bystander. I was standing by. I was there. I seen the fight. Wait a minute. Y'all had said there was no fight in Cabo. So now you're a bystander to this fight. So now through this civil case, they are going to be snitching on each other and telling on each other to be a part of their own defense. Khalil does not want to be implemented and be a part of, you know, being sued and owing a lot of money for something he feels he's just a bystander to. Now, we all know bystander, you could have stopped the fight. And by the way, I don't like to say a fight. It's not a fight, it's an attack. They say fight, it's an attack. Shanquella was not hitting back. She was not doing any of that. It was an attack on Shanquella. A savage attack, a brutal. Okay, so a brutal attack. So bystander Khalil Cook and he makes sure he's not like saying that he was a part of anything. He's standing on the side. Arising out of a fight, no attack, between two of his travel companions on a trip to Cabo San Lucas, Mexico. So he's telling on Dani'S right here, Dani'S, you and Shanquella, and you're the one, Dani'S, that were attacking Shanquella. Now he's trying to say fight. This is my own wording. And I was just a bystander to it. So Khalil is ready right now that he's going to really throw you under, Dani'S. If y'all had any sort of pact or any sort of agreement to keep things silent or quiet, that is out the window. That is out the window because Khalil is saving his own ass. And this is what I was hoping for. He is saving his own ass. I'm a bystander, and that's you, Dani'S. Shanquella is no longer here. So you were, he says two of his travel companions. So he's saying Dani'S and Shanquella. And he said everyone else are bystanders, including himself. So they are ready to throw you under, Dani'S. Okay. Mitch Robinson died in Mexico in the hours following the what? Mitch Robinson died. Shanquella died in Mexico in the hours following the attack. So, he is telling on you, Dani'S, that following the attack that you did on Shanquella, that she died in the hours following it. Plaintiffs claim that Ms. Robinson was unalive and that there was a conspiracy among the defendants, all of which allegedly occurred in Mexico. However, there is no allegation that defendant Cook participated in the fight, attack, or touched anyone. Moreover, there is significant disagreement about whether Ms. Robinson was unalived, who was involved, whether the defendant tried to evade capture, and whether there was a conspiracy. Numerous important witnesses reside in Mexico who possess relevant information regarding plaintiff's claims and Mr. Cook's defenses to those claims. Those witnesses include medical personnel who treated Ms. Robinson and were in the hotel room prior to and shortly after her death. Hotel personnel may also have potentially relevant information. Moreover, critical witnesses include Mexican law enforcement who responded to the scene, as well as the Mexican coroner's office who forensically examined Ms. Robinson's body and opined on her cause of death. All of these witnesses will likely be an essential part of any trial of this action. Further, a substantial part of plaintiff's claims occurred in Mexico and will be governed by Mexico law. Mexico has a civil justice system where plaintiff's claims can be adjudicated. Yeah, but we don't know if it's too late to file there. So no, y'all need to stay right where y'all at, because the victim resides there and a lot of y'all reside there and were there. Now, to be honest, there's probably only one person that can try to really argue, and that's because he's out of Connecticut. But by the way, that the private investigator said that he was back and forth between North Carolina and Connecticut himself too. Okay, issue presented. By this motion, defendant Cook presents the following issue to the court: whether the court should stay this action and follow it to proceed and allow it to proceed in a foreign jurisdiction where many of the claims occurred. North Carolina has codified the doctrine of forum non convenience as follows: if any action pending in any court of the state, the judge should find that it would work substantial injustice for the action to be tried in a court of the state, the judge, on the motion of any party, may enter an order to stay further proceedings in the action in the state. A moving party under this subsection must stipulate his consent to sue in another jurisdiction found by the judge to provide a convenient, reasonable, and fair place to trial. But y'all are not going to consent. Please stop. No. This stays in North Carolina. Stop trying to get this sent to Mexico. It might be past the statute of limitations, and y'all are not going to consent to Mexican jurisdiction. Y'all are not Mexico jurisdiction. Y'all are not. So no. And secondly, we have to be honest here. You, Khalil Cook, and the others, y'all knew exactly what was going on. Y'all knew what happened. So right now in this document, you can say you witnessed something and that Shanquella died within hours of that, what you witnessing her being attacked. She wasn't fighting because she was not hitting back or anything. She said she didn't even want to fight. So that wasn't voluntary. She was being attacked. So you can witness that now and say what that happened. But what happened when you lied? What happened when you lied when you came back to the United States and you lied on the phone about what happened to Shanquella? But now all of a sudden you know what happened. It's interesting now that your memory is back. Interesting. And we have to be honest. Who was there when she was unalived? The doctor was not there when she was unalived. The maid wasn't there when she was unalived. The concierge wasn't there when she was unalived. Only the Cabo people were there. And now I will say this: when she was unalived, Nazir wasn't there. People are gonna argue, but he didn't come until later on. Okay, he didn't come until later. Let me say this. He didn't come until Shanquella, until after this attack. So once she was already attacked, that's when he came, after she was attacked. And she was already on the couch or in that other space. Okay? So as far as the people there when she was attacked, and this is all gonna come out. He wasn't there when she was attacked. He arrived later, and even the concierge already attested to the fact that he arrived later. Okay. Now, as far as who was the bystanders in that room, all the people that matter as far as her unaliving, all the Cabo Six, all of y'all are the ones that can give answers to this. Yes, do we need the doctor? Yes, do we need the paramedics? Yes, do we need these people to give their side of the story? Yes. But a trial can still be here to North Carolina with Nazir there, with Dejanae, Khalil, Elise, and everyone there. Y'all can still hold the trial to North Carolina to get to the bottom of this, because y'all were the ones there when she was attacked. And y'all were the ones there when she stopped being able to move on her own. Okay, so that's the part that we are concerned about. Okay, who can attest to that? So with that being said, y'all are the main ones that. So this can be healed fairly in North Carolina based on who was there when she was attacked and who was there right after. Okay, and who had the duty to report what happened. Okay. And who concealed what happened. Okay. When it appears that North Carolina is an inconvenient forum and that another is available, which will better serve the ends of justice and the convenience of the parties, a stay should be entered. The Court of Appeals has identified a number of factors for courts to consider when addressing a forum non-convenience issues, which include the nature of the case, the convenience of the witnesses, the availability of compulsory process to produce witnesses, the relative ease of access to services, to sources of proof, the applicable law. Now, does he have some points as far as certain evidence and certain things that happen and why it would be better in Mexico? Yes, but this is not. Let me be clear. Khalil does not give a fuck about a fair trial. He does not care about it be like having the doctor's testimony and everyone's testimony. This is all a ploy and a play to get the judges say Mexico is the best place to have this stay and stopped in North Carolina where he's at, and to then try to have them do it in Mexico where it might be too late to file a lawsuit because of statute of limitations. It might be too late. People are not going to consent to Mexico jurisdiction, and it's not going to be able to happen in Mexico. This is a way to get this case stalled and dismissed out of North Carolina and just thrown out. That's all it is. It's not, he doesn't really care about any of this stuff. And the burden of litigating matters not of local concern, the desirability of litigating matters of local concern and local courts, convenience and access to another forum, choice of forum by plaintiff, all practical considerations. It is not required that the court consider all these factors in every case as unique. Circumstances of a particular case may make some factors more relevant than others. I'm not going to read all of this, but pretty much, hold on. Yeah, I see the game, and the game is to try to get this stopped in North Carolina and sent to Mexico, where people are not going to consent to Mexican jurisdiction, and they're not going to, it might be too late to even file a claim over there. Here, Mecklenburg County Superior Court will face the same practical burdens identified by the court in Hinquin. Approximately 4 causes of action out of the 6 remaining causes of action of plaintiffs' asserted claims are governed by Mexican law, placing this court in a position of having to interpret, apply, and explain unfamiliar foreign legal principles throughout the life of the case. The application of foreign law would almost certainly require the retention of experts in Mexican law, not only at trial, but at the outset of the case for purposes of resolving dispositive motions, evidentiary issues, and crafting appropriate jury instructions. Now, to be honest, I would say that he probably has a better argument. He probably has a better argument than Dani'S. He probably will have the better, to be honest, to try to say, because that's going to be, Lord have mercy. But I don't see how that's going to be fair, because I don't think that is. I think it's past the statute of limitations, so there's no way that's gonna be unfair to the plaintiff if it's too late past the statute of limitations to file a claim in Mexico, and the people are not going to consent to Mexican jurisdiction. So it's kind of like you're trying to offer something that you know is impossible, the impossibility of it. So the judge should not, go with this. This is just a way to get this dismissed. This is, yeah. So I don't think this will actually work. The amended complaint involves substantial interactions with hotel workers, law enforcement, doctors, and forensic medical examiners who are all located in Mexico. Further, the parties were all in Mexico, and the applicable claims against Mr. Cook directly involve Mexican tort law and theories of civil negligence, contributory or comparative negligence, bystander duties, and medical treatment, among others. All applicable claims should be determined by the laws of Mexico. So then now he's gonna talk about people that he feels should be added. The material witnesses necessary to develop these facts are based in Mexico, and upon information to believe include the following: Carolina Beatrice Ornelas Gutierrez. Oh my gosh, that name I haven't heard in a while. That's the doctor who is alleged to be the healthcare provider who provided medical treatment to Shanquella Robinson as per Exhibit B of plaintiff's amended complaint. Suni Popoco Milan was alleged to be the police officer and police investigator who interviewed the Carolina Beatrice Ornelas Gutierrez as per Exhibit B of plaintiff's amended complaint, and who also authored the Mexican police investigative report as per Exhibit C of plaintiff's amended complaint. Dr. Alvaro Adelano. Now, I talked to this person too, and he's a jackass. He was alleged to have been consulted during life-saving measures that were administered to Shanquella Robinson as per Exhibit B of plaintiff's amended complaint. Emergency medical staff with Red Cross ambulance. Common sense indicates at least 2 witnesses who were consulted during life-saving measures that were administered to Shanquella. Now, I will say this: a lot of those people from the paramedics, some people, spoke English, some did not. Emergency medical staff from 3 ambulances. Common sense indicates at least 2 witnesses per ambulance for a total of at least 6 witnesses who were consulted during life-saving measures. They were administered to Shanquella Robinson as per Exhibit B of plaintiff's amended complaint. The same thing that the other 3 ambulances that came to the scene told me. The municipal police officers, at least 2 and likely more, who allegedly conducted an investigation to Shanquella Robinson's death, as per Exhibit B of plaintiff's amended complaint. The municipal police officers had already arrived at the scene. They asked me about the patient's condition. I waited for them to finish interviewing one of the Red Cross paramedics. One of the officers took my statement. Here's my thing. I totally get that there's another group of people that should be added to this whole lawsuit, but I don't think it's feasible for all. I don't think that everyone in Mexico is going to come over to the United States and be tried, and vice versa. It's not going to work. There's probably going to have to be, and to be honest, they already took a lot of these people's statements. We haven't heard y'all statements. We've heard from the doctor and other people in their statements, right? And those documents that were released. We haven't heard y'all's testimony, y'all statements. So we're looking for y'all's side and what y'all have to say, right? So the family can technically use the statements already from Giovanni and the concierge and other people, and what they've already gave statements. Where are y'all statements at? Okay, Giovanni, the administrator, as alleged per Exhibit B of plaintiff's amended complaint. The Giovanni administrator arrived and officers told me that I could not leave yet. Moreover, Exhibit B to plaintiff's amended complaint begins with page 34 in the top right-hand corner. Thus, there are 33 pages of the Mexican Police Department's report that are unaccounted for, and common sense indicates that additional witnesses are identified in those 33 missing pages. Dr. Rene Alberto Galvan Osegura, who is alleged to be the forensic examiner who performed the autopsy of Shanquella Robinson, as per Exhibit C of plaintiff's amended complaint. Christian Armendariz, who is alleged to be the general manager of the hotel Aeropuerto Puerto Los Cabos, which is where the individual defendants were staying and where Shanquella Robinson passed away. And as per Exhibit C of plaintiff's amended complaint, the police chief Juan Pablo Sepulveda, I don't know. It said, I guess, Sepulveda. So let me see, Sepulveda, who is alleged to be one of the lead police officers who was in charge of the Mexican Police Department's investigation into Shanquella Robinson's death, as per Exhibit C of plaintiff's amended complaint. Lieutenant Commander Aaron Bautista Alvarez, who was alleged to be one of the lead police officers who was in charge of the Mexican Police Department's investigation into Shanquella Robinson's death, as per Exhibit C of plaintiff's amended complaint. General Director of the Control Center Communication and Computation Command for the Baja California Sur State, Bruno Calmar Cantarell Maturino, who is alleged to have been involved in an investigation into Shanquella Robinson's death. So I'm not going to read all these names, but as you can see, he's giving other people's information as far as who he feels. Eduardo Trinidad Perez, who is alleged to be the criminal expert. Evidence room assistant as well, as going down the line. Moreover, Exhibit C to plaintiff's amended complaint, which allegedly contains a portion of the Mexican government's official report of its investigation into Shanquella Robinson's death, begins with unnumbered pages, but then lists page 88 in the top right corner. Thus, there are dozens of pages of the Mexican Police Department's report that are unaccounted for, and common sense indicates that additional witnesses are identified in those missing pages. Consequently, based on this tally of witnesses who are identified in plaintiff's amended complaint, there are at least 24 witnesses who reside in Mexico. These witnesses have important information regarding Shanquella Robinson's death. Now, to be fair, do I agree they have important information regarding Shanquella's death? Yes, but I also believe that this information can be obtained through those reports. If you say pages are missing, then those can be obtained and used. And maybe, to be honest, I think the family did receive information. Maybe they didn't want to release all the packet they received, but I know that the family did receive stuff, and I think Sue Ann did release some of the information, right? That we went over before. Now, would it be smart for them to release all the information to the public, knowing that they have not got full justice and people might be trying to learn information so they can make up a story around it? I would not. Most police don't even do that. If you give everyone all your information that you know about what happened in Cabo, and the Cabo, the fake friends could start lying and making up stuff after they read it. A lot of times liars, they like to know everything you know and what you got on them so they can make up a story around it. So you never release everything you have or say everything you know, so that way they won't be able to try to get an alibi or make up some sort of story or lie about the situation. You keep some things in the back of your hand. You don't let everyone know everything you have on them, right? And that's how some people tell on themselves, because they get too comfortable thinking that, even like the deeper BD, he probably thought he was safe, that he was free, they were not arresting him, that he probably thought he wasn't even like a full suspect, and then boom, he's arrested, and they have all this evidence against him. So you never let people know all your information. You keep it, you hold on to it, and then when it's the right time, boom, you pop it down, okay? So that he's trying to argue. So he said these witnesses have important information regarding Shanquella Robinson's death, as well as the defendant's actions prior to and after Ms. Robinson's death. It is self-evident that a court in North Carolina will have little to no success in compelling the testimony of these witnesses, of which there are many and which comprise the overwhelming majority of known witnesses. Well, this is the issue. You say that the North Carolina court is going to have issues compelling the testimony of Mexican citizens, residents, and the same can be true of the opposite. If Mexico is going to have a hard time compelling the testimony of y'all bitches in North Carolina, y'all are not going to cooperate with Mexican. Even right now, when Desjardins Manhan Jackson knows she has a warrant in Mexico, is she really gonna turn herself over to Mexico willingly? No, she's not. So we already know, if something is in Mexico, y'all are not gonna, y'all gonna say fuck Mexico, because y'all know y'all have to be extradited back there to, enforce back there. And without that, if you never step foot in Mexico, you're not gonna care about warrants or even a civil judgment against you, because it's Mexico. So you think he's slick by trying to recommend Mexico when you know that you're not going to consent to anything in Mexico. As for witness, and if you do consent to Mexico, guess what? It's still a civil case, and if there was a judgment won, you still are not, like, this is all a game to really just try to get this thrown out. Okay. As for witnesses who do not reside in Mexico, the material witnesses are the parties themselves. The parties are available for questioning regardless of whether lawsuit is pending. Okay, if the parties are available for questioning regardless of whether lawsuit is pending, then that can be said for Mexico, that even though the lawsuit is pending here, they can still say he's saying, but the same is not true for the Mexico-based witnesses. That's not true. They have already gotten statements from Mexico before, so I'm sure they could do it again. And in a state court in North Carolina, Mr. Cook has no ability to compel the testimony of the applicable witnesses to present a fair defense for the court and jury to determine the issues on the merits. So he's saying he can't compel the testimony of the witnesses from Mexico. But how can it be the opposite way either? More of a court in Mexico is in a significantly better position to evaluate and apply the laws of that jurisdiction to the alleged facts in this dispute, as well as to compel the testimony of witnesses. By any measure, this case should be decided in the civil court in Mexico. Nah. Anyways, I'm not gonna continue reading this. But essentially, Khalil Cook, I'm sure y'all got the gist and you understand. Khalil wants this tried in Mexico. Based on the relevant factors, the court should stay this case. Stay this case and try it in Mexico. And he says, this case centers around events that occur entirely in Mexico. Nope, nope, nope. Y'all concealed things when y'all arrived back in North Carolina. You lied. When you were in Mexico, you called North Carolina to lie. You also went back to North Carolina to the residents in North Carolina to lie and conceal elements of this crime. So no. And depends on testimony of numerous material witnesses who reside in Mexico, requiring a North Carolina court to apply Mexican law to the majority of plaintiffs' claims, coordinate with experts on Mexican law, and proceed without access to key witnesses would impose a substantial and unnecessary burden on judicial resources. No, they're focused on the wrongful death of Shanquella, and they can try this case on the wrongful death of her with the people present, because the main thing that happened was the attack on her. You call a fight, but it was actually an attack. That's something that y'all all witnessed, and we already know, you know. Now, I will say this. He does have good points. So this is going to be, I'm not going to try to just, you know, fake it. He does have good points as far as Mexico being a proper venue, but there's also good points to why North Carolina is a proper venue too. Okay? Especially because it's not possibly even feasible for Mexico, especially at this point with past statute of limitations. Possibly passed. Mexican courts are best positioned to act as the operative forum for this case and apply substantive Mexican law accurately and efficiently. Accordingly, because the relevant factors establish that Mexico is a more appropriate forum, the court should exercise discretion under that law and enter an order staying this action. For the reasons stated herein, the undersigned respectfully moves the court to stay this action and allowing it to proceed in a foreign jurisdiction. No, 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 no. Keep this case going, and I can already see people squealing like little pigs. I can see y'all squealing like little pigs trying to tell on each other. We need to keep this case where it's at in North Carolina and keep it going and get past the service part, get past this personal jurisdiction and these procedural issues, and let's get to the meat and potatoes where y'all answer and y'all argue back and forth about what happened, and we get some answers finally. Keep it here. And I'm sure that everyone else in Mexico has already been questioned, and we already have statements. There's already a statements released from the doctor. There were statements released from the concierge. Y'all remember I talked the concierge that was there with them. I talked to that person for 3 hours, and then I talked to them later. The lady that actually, you know, helped, you know, dress Shanquella and send her back home in Mexico, I talked to that lady. So ultimately, this needs to stay in North Carolina. Okay, so now let's see what other, I'm trying to speed through this. I know I'm not trying to stay for long, but this is like a catch-up live, and a catch-up live, sometimes you have to make sure that I'm trying to catch y'all up, because next week is court, and by the time next week comes, I want everyone to at least know what's happening and what the arguments are for these defendants, okay? So I talked about how Dejeuner is going to be heard next week, but you know, it's best to hear all arguments on the same day. So on that same day, May 13th, May 13th, 2026, defendant Khalil Cook's motion to stay case will take place as well on May 13th. So we will get answers as far as what the judge or what the courts will decide based on their arguments. Okay, bear with me, I'm almost done. Okay, this one I don't need to read, just about lawyer stuff. Pro hoc. Sometimes if a lawyer is out of state and they want to represent someone in a different state that they're not They're not licensed to practice in. They can appear pro hoc. They can have a local lawyer kind of sign for them to, appear so they can still represent someone through a local office. Like if it's like a New York lawyer, let's say, and they want to represent someone in North Carolina, they're not licensed to practice there, but they can appear pro hoc through that local office. It's kind of like they're going to supervise the case in some sort of way like that. Okay, basic of it. Uh, Let me see this one. Notice of civil motion hearing to be held in person. Okay, so let's see what else is here. Then I'm gonna get some shout outs in just a second. Okay, well, this is like the complaint. I went over the case of the complaint when it first came out. And what's this last document? Let me read this one. Let's see what it is. I mean, okay, I already went over this initially. And this is what they are going to be really going over, really, is the verified amended complaint. This is the complaint, the filing that brought this action. And this is the amended version, okay? And it was 43 pages, and this is what started this lawsuit, okay? And once I had kind of informed everyone that her new name was Imani Green, once they amended the complaint, they changed her name, and you can see this on line 5. Defendant Imani Green, formerly known as Dani'S, okay? And sometimes when you file a lawsuit and if you have the wrong name, you can't really enforce anything or do anything with it until you update the lawsuit with the real name, amended with the person's real name, so you can enforce anything later, okay? So that's why her name now is Imani Green on the amended complaint, and on the original complaint it was Dani'S Jackson, okay? Now you might can't win a judgment with the wrong name on it, but as far as enforcing anything, you need the person's real name attached, okay? Yeah. So now that's pretty much gonna be it, y'all. I love y'all and I appreciate y'all for tuning in. This live has been 3 hours, but it has been, a lot of stuff has happened. So anyways, I will just say continue prayers to the family, and by tomorrow morning I will update the petition with this information, kind of summary of what I talked about and discussed, and also with the upcoming court date. I'm just praying that this case continues in North Carolina, that it's not stayed to try to, anything about Mexico, that I'm hoping that Dani'S does not win her motion to dismiss based on technicality and procedural things like, service, like the insufficient service or process, okay? Anyway, shout out to Cheyenne. Happy 28th month anniversary. I think I gave a shout out to you already, just in case I did. Happy anniversary to Cheyenne. Yes, Avengers Forever. Shout out to Lisa Taylor. Happy 27th month anniversary. Yes, I appreciate the support. Again, shout out to you. I appreciate the support. Yes. And also, if you're on this channel, make sure you're only on the $2.99 package. Make sure you don't get the highest price, because I'm not over here enough for that, right? So make sure you're on the lowest plan. Shout out to Lemon. Thank you so much for renewing your membership. I appreciate the support. Yes, and yes, I appreciate the support. Shout out to OGTN Baby. Thank you as well. Thank you so much for renewing your membership. I appreciate the support. And shout out to Tiffany as well. Thank you so much for renewing your membership. Yes, and yes. And everybody else, remember, support my channel for free just by what? Hitting that like button. And one more thing. Shout out to Chanel. Thank you so much for the cash app. She had says, great interview. She had caught the replay of my interview on my channel Messy Lounge. Make sure you check out my channel Messy Lounge. Yeah, so anyways, I love y'all, and I will see y'all on the next live. And like I said, tomorrow, I know I put it in my title that I'm going to update on Mr. Prada and Dakara. I'm going to add that to my tomorrow's show. So come to my main channel, Danny Roberts, and I will update on those two cases. And that's where I should update it anyway, because that's where I initially reported on it. So look forward to those updates. But yeah, so I can't wait until this proceeds. And I hope it gets past the motion to dismiss stages next week and move into the answer. Because when people start answering and they start, you know, if it goes to trial, because guess what? Pay attention to the top words right here. Jury trial is demanded. They want a jury trial. So if this continues, it could possibly get to a jury trial, and that's where we will get a lot of answers, because people want to save their neck, save their own asses and hides, and they don't want a public backlash from a lot of people. So to protect themselves, the alleged bystanders are going to snitch on Dejanae and have her, you know, and I hope the court sees through Dejanae trying to change her name, trying to move to Connecticut, trying to hide out, trying to not disclaim, you know, all her North Carolina connections, trying to really weasel her way out of this whole situation. She's so fucking gross. Yeah, I had to get off here because I cannot stand Dejanae. When I say I can't stand her, I can't. It's like she ruined someone's life. She unalives Shanquella with all her, you know, life and future ahead of her, and all she cares about is her own ass. Oh, I moved, I got a job. Oh, I don't, you know, and trying to change her name. It's like she only cares. Like she's so gross. So I had enough of this Dejanae for right now. But hopefully the judge sees past her bullshit, because she feels like she can get away with everything, and I hate that she feels that way. And hopefully that's not the case, because if they dismiss because of lack of service, imagine that, dismissing this whole thing because she wasn't properly served. That's ridiculous. It's bad. They have too much evidence to show they really did due diligence to serve her. And to be honest, her own evidence could be used against her. Tammy texted her and said that someone brought stuff to serve me your stuff. Like, I have stuff here for you that was served for you. Like, you know, so she notified you of it. And sometimes they do go by sometimes someone's previous or past residence. So anyways, we'll see what happens, y'all. Yes, continue with justice for Shanquella. And that's why I said, let me tell y'all something. I am going to be pissed off if they dismiss Dejanae's case against her for some stupid shit like service, when it's clear that she was served based on everything and all these receipts and things. She was served. And don't forget, she already answered the complaint. Let me actually look up something real quick. I want to make sure. I'm gonna Google this because I want to make sure. Because I think she already answered the complaint, but I think it was the initial complaint. Hold on one second. Usually, if you're trying to get something dismissed based on service, you shouldn't answer the complaint. Answer means you're responding to the facts and the merits and offering defenses. So usually you're waiving your rights for service arguments when you do that. Not always. Okay, so it looks like she probably did preserve, like she answered it, but then preserved it. I would have to go back and look at the documents fully myself. But yeah, sometimes that is the case, unless you preserve it when you're answering. Anyways, I'll see y'all next slide. Bye.